Abuse lordship. My lord, he works as employee. A similar order has been passed in other cases. My husband was the worker, she died, so I am a widow. It may kindly be listed on 30.
On
29th, sorry.
after Diwali. After Diwali. First week of November. Next matter, please.
Okay.
May it please your lordship. Lordship, I beg to mention a repetition for motion, your lordship, on Monday. It is
What is the matter?
it is regarding selection in the Central Armed Forces, your lordship. The petitioner was rejected due to height.
When was the selection conducted?
The rejection was done on 7/10/24, your lordship. However, the process is still ongoing, your lordship. So the prayer is to reconsider his measurement, your lordship.
30th October.
DPO.
Yes. Lordship, I am praying for listing an admission matter, Lordship. Admission, Lord. It was last listed on 6/8/24.
Second week of November. Yes.
May it please your lordship, I beg to mention WPC number 5318/2024. One necessary party has been left out to be impleaded, your lordship. We want to file an IA.
The matter is listed today.
Not listed, your lordship.
File the IA, it will be listed. File it.
Obliged.
Daily list promotion item 1.
Wait, your lordship.
Yes. Where is the operative part? Page number?
Page number 58, Lordship. 11%, Lordship. Paragraph 25, Lordship.
So it has not been reinstated.
Lordship. Thereafter, the respondent authority, Lordship, filed the appeal, Lordship, the division bench, Lordship. This petition has been dismissed, Lordship.
Your name, please?
MZ Shah.
Or Mr. MJ shall and counsel for the petitioner alleging willful disobedience of the directions contained in order dated
25/10.
25/10/2017. When was the division bench matter dismissed?
Lordship, division bench dismissed, Lordship. 4th of February 2022.
Oh, then you have come late. More than 1 year has gone. 1 year is the time, is it not? Then
Lordship, several petitions filed, Lordship. Assess that.
Mr. So prays for it is granted 10 days time to examine the legal issues and address this court to satisfy that the contempt petition is not barred by limitation. You find out what is the way out.
Item 2.
Lordship, the matter may be listed in connection with contempt case number 145/2018, Lordship.
First, let us see what happens here.
Lordship.
Please, your lordship.
Yes.
The matter pertains to non-payment of leave encasement and gratuity, my lordship.
Mhm.
And the order is at page 12, your lordship, operative portion, my lordship. Para 7 onwards, my lordship.
Heard Mr. P.S. Rajaran, counsel for the petitioner alleging willful disobedience of the directions contained in the order dated 30/8/2023 passed by this court in WPC number 4594 of 2023. The instant petition has been filed. Peruse the statements made in the contempt petition. Issue notice returnable in the text. Petitioner will take steps.
Obliged, your lordship.
Item 3.
My observation. My lord, operative part of the order is at page 15 and 16. ma'am.
What has happened?
My lord, despite of the stay order, my lord, not to take coercive action, my lord, but State Department has taken coercive action.
What is the action taken?
That action, lordship will see at page 18.
Yes.
19 is the operative part, my lord. Now the government of Assam is pleased to impose a penalty of recovery of loss basing 1,75,000 so and so from the pension of the Rafiqul Islam Forest Reservation. Okay, good.
The contempt or motion.
Okay, yes.
You're there,
I know this particular case, madam. So I heard the name, so I came on. Okay,
this is Forest Department.
my lords.
So why don't you find out what has happened? We'll post it next week. Give him a copy of the petition. Mr. Jay Gabriel and counsel for the petitioners. Heard. Having gone through the materials on record, Mr. D. Gogoi, learned standing counsel Forest Department is asked to obtain preliminary instruction as to whether the order dated. What is the date of the order? It is undated.
Dated, my lord.
What is the date?
1/5/24. Page 15.
No, order of penalty.
Penalty order dated, my lord, 19/8/24.
Order 28, 2024 has been issued in violation of the order dated 1/5/2024 passed by this court in WPC number 2259 of 2024. A copy of the contempt petition be furnished to Mr. Gogoi during the course of the day. This case again on 29/10/2024 by reflecting the name of Mr. D. Gogoi in the call.
My lord, standing counsel Forest Department's name be reflected next date. my lord.
Second floor.
Always, my lord.
May it please your lordship.
Yes.
My lord, the operative portion is at page 16. By this order, this honorable court directed my lord reinstatement and other service benefits, but same has not been paid. The order was dated 22/2/2024.
But the 8 weeks time has gone. 8 weeks time frame has expired.
Then the second paragraph,
I counsel for the petitioner alleging willful disobedience of the order dated
page 11, it starts.
22/2024 passed by the 11th single judge in WPC number 6682 of 2024. This contempt petition has been filed. I append the statements made in the petition, issue notice returnable in expedition and text.
Deeply obliged.
Item 5.
Please, your lordship, the operative portion is page 17, my lord. Para 6, the directed to examine, my lord, within 8 weeks, my lord, but not done, my lord, nothing has done, my lord, that's why, that, my lord. That,
But Mr. C. Yaswant, I counsel for the petitioner alleging willful disobedience of the order dated 26/6/2024. Passed in WPC number 840 of 2024. This contempt case has been filed. Partition है क्या होगा?
okay.
Item 6.
May I appeal? This contempt petition, operative portion, page 12, paragraph 7. Is regarding unpaid, arrear unpaid salary of the petition.
Mr. A. Bhattacharjee, order dated 5/2/2024 in WPC number 1557 of 2020. Partition है क्या होगा? Yes, take steps.
Like,
Item 7.
may I please, lordship?
Yes, what has happened?
Lordship, they have filed appeal yesterday only, Lordship.
The petitioner has submitted a fresh appeal, lordship, on yesterday, lordship.
So,
They will take necessary action, Lordship.
right, take down. But Mr.
And M. Agarwal.
And I'm Otherwell, I counsel appearing for the petitioner, also had Mr. S. Dr. understanding counsel
Revenue.
Revenue and Disaster Management Department, Government of Assam, as well as Mr. C.S. Odhaikar, learned government advocate, appearing for the official respondents. In terms of the, invite like this.
110.
The lead petitioner had submitted his candidature for selection and appointment to the post of Gao Pradhan of Amraguri, Yenarburi, and Satyantuli Kisam in Lahorighat Moja under Lahorighat Revenue Circle in Morigaon. Pursuant to the notification dated 7/7/2022 issued by the concerned authorities. However, upon conclusion of the selection process, the respondent number 7 herein was selected. Respondent number 7 was selected.
Yes, Lordship.
Mr. According to the petitioner, the respondent number 7 has submitted false documents, and therefore his selection is liable to be cancelled. Taking note of the petitioner's counsel has further submitted that although an appeal was preferred before the appellate authority in terms of the provisions of Rule 162 bracket C bracket close of the executive instructions framed under the Assam Land and Revenue Regulation 1886. The said appeal has not been disposed of till today. Hence this writ petition. Taking note of the grievance expressed in the petition, this court had passed order dated 1/10/2024 in this case, directing the petitioner to submit a fresh appeal and also granting time to the learned standing council PNR Revenue Department to obtain instruction in this regard. Today, when the matter is called up, Mr. S. Dutta, learned SC Revenue Department submits that the petitioner has submitted a fresh appeal yesterday, and the same would now be taken up for disposal in accordance with the provisions of the rule. If that be so, nothing further survives for adjudication in the writ petition at this point of time. Therefore, providing that the appeal preferred by the petitioner be disposed of in accordance with law after hearing the affected parties within a period of
90 days.
preferably
Lordship.
within a period of 90
90
days
days.
from today, this writ petition stands disposed of. If the petitioner continues to remain aggrieved in the matter, it would be open for him to approach this court once again by filing fresh writ petition.
Great, Lordship.
May I please?
Yes.
My lord, wife of the petitioner number 1 and the mother of the petitioner number 2, she was discharged from service by order dated 8/7/2013, my lord, on the allegation that absent from duty and going outside the state for treatment without permission, my lord.
So
She
you are
preferred an
terminating
appeal.
the order after 11 years.
No, my lord. She preferred an appeal immediately. That was kept pending. In the meantime, she died, my lord. The appeal remained pending, my lord. In the year 2023, the daughter, my lord, petition number 2, she made an application under RTA. What action has been taken? That replied, my lord, was page 92, my lord. They have replied, my lord.
But these are personal relief. How can the daughter pursue it?
No, my lord, that if we are challenging the order of discharge, it is saying that it is
That is
disproportionate.
correct. How can the daughter challenge it?
No, my lord.
Supposing it is set aside,
Yes, please.
can a dead person be reinstated?
No, my lord, not for the her prayer in the appeal was that she may be allowed to go on invalid pension or my lord, yes, please, invalid pension.
Counsel for the petitioner. The petitioner herein is it's not the daughter who has come before the court.
The father and the husband and the daughter. Petitioner
The
one is the
husband
husband.
And the daughter of deceased government employee, namely, what is her name?
The Manjushree Rana Barua.
Manjushree Rana Barua, internally assailing the order of discharge from service dated 8/7/2023 by contending that the said order was not only illegal, but was highly disproportionate to the allegation brought against the deceased employee. Mr. Mr. Hazarika submits that instead of order of discharge, the facts and circumstances of the case would at best justify an order of retirement of the
Compulsory retirement and
order of compulsory retirement of the deceased employee by granting
invalid pension.
invalid pension. Ms. M. Bhattacharjee, learned additional senior government advocate Assam, and Ms. S. Sharma, learned standing counsel.
I'm
Ms. M. Bhattacharjee,
one,
learned additional senior
3,
government
4 and 6 lordship.
appearing for respondent number 1,
3, 4 and 6.
4 and 6, and Ms. S. Sharma, learned standing counsel, Health Department Assam, appearing for respondent numbers 2
2 and 5.
and 5, have questioned the maintainability of the writ petition by arguing that the relief sought for being personal to the deceased employee, the same cannot be maintained by the family members of the deceased employee. The learned department counsel have however prayed for some time to obtain instruction and file affidavit. In view of the above NOM 8 weeks, since the respondents are already represented, no forming matters. Extra copy will be furnished. to
Well,
presenting members.
Let's remember.
Publish.
Item 9.
My lords, I'll seek adjournment for this matter, my lords. My colleague Partha Medhi was there. He couldn't come, my lords. It's just interesting. Next week, my lord, he
On the
did.
prayer of London Council for the petitioner, these matters to pass to list again in the next meeting.
Always, my lords.
Item 10.
May it please your lordship. These are master role workers and workers. They were working from 1980 to 90. From 1985, the appointments were there. I'm praying for their regularization based on 2 judgments. One in passed in 1994, wherein similar petitioners, in fact, one of the petitioners herein had received an order for regularization, and pursuant to thereof, there's a latest judgment now, wherein similarly placed persons have been given the benefit of regularization, your lordship. So the prayer is for regularization, basically.
Well, you should notice that.
Yes,
this
Your
is
Lordship.
not
As of now,
notification
notice.
Counsel for the writ petitioner, the petitioners herein are working as master role.
Water Resource Department.
What judge? So casual employees in the water resources department. According to the petitioners, they were appointed during the period from 1985 to 1990. Mr. Sharma submits that in view of the decisions of this court rendered in the case of.
Rendered in the case of, I'm placing latest judgment.
Give the judgment.
Yeah, I'll give.
So and so and so and so, the petitioners are entitled to be considered for regularization of their services. Mr. Ms. J. Gogoi, Learned Standing Counsel, Water Resources Department, however, prays for some time to obtain this instruction and respond to the plea raised in the writ petition. In view of the above NOM 86, Mrs. Ms. Gogoi has appeared and accepted for all the response. No formal notice is required to extra copies.
I'll write in a slip and give, lordship. I'll write in a slip and give.
Yes.
Item 11.
May I please, your lordship. My lord, due to non-payment of area family pension, my lord. So this petition is filed, my lord. The petitioner husband died in, petitioner's father died in harness, my lord, during the service as tax collector. So his service was,
of compassionate family pension.
no, my lord, family pension because his mother died. So till the date of his mother, my lord, he is entitled to pension, my lord.
Notice may be issued, my lord, at this stage.
My lord.
Mr. M. Islam, Learned Counsel for the petitioner. There is the amendments made in the writ petition. The grievance expressed in this petition pertains to non-payment, alleged non-payment of family pension, which the petitioner claims to be entitled to under the law. Mr. S. Datta, Learned Standing Counsel, PNRD Assam, prays for some time to obtain instruction in the matter. NOM 8 weeks, since Mr. Datta has accepted notice for respond numbers
1, 4, and 6, my lord.
1, 4, and 6. Mr. R. Bhattacharjee, Learned SC Finance for respond number
3 and 7, my lord.
3 and 7. Mr. C. S. Hazarika, Learned Government Advocate Assam for respond number
2 and 5.
2 and 5. Service of notice is given to be complete in this case. Extra copy of the reputation is furnished to the
Only oblige.
Department Council so as to enable them to obtain instruction.
Oblige.
Item 12.
May it please your lordship.
Yes,
My lord, the petitioner's mother died in harness, leaving her as the sole.
died in
detained.
harness is only dismissal at motion or dismissal at admission. That's the only argument you can do.
They are paying for pensionary benefits,
Hmm?
family pension.
Yes.
They are not getting, they are not getting family pension.
Oh, it's family pension.
Yes, lordship, family pension.
Compassionate family pension.
Family pension, lordship. Her mother died in harness, thereafter she have died. She is the sole legal heir, lordship.
Okay, and it is different.
Yes.
So,
My
what's
lord,
your
I'll take instruction, lordship. Overt case, lordship, the similar issue has been decided by this honorable court, lordship. Family pension. Another one, revenue.
Your opinion, all right. Heard Mr. M.I. Hussain, learned counsel for the petitioner, peruse the amendments made in the read petition. After the untimely demise of mother of the petitioner, she was entitled to receive family pension under the rules. Full stop. However, agreed due to non-payment of such family pension, the petitioner, who is the daughter of the deceased government employee, has approached this court by filing the writ petition seeking a writ of mandamus. Mr. Islam submits that, Mr. Hussain submits that the case of the petitioner is covered by the decision of this court rendered in the case of Hasiba Begum versus State of Assam and others, reported in 2022, bracket 1, bracket close, GLT 353. Mr. S. Dr. Understanding Council, PNRD, Revenue Department, Assam, and Ms. M. Bhattacharya, learned additional senior government advocate, Assam, have prayed for some time to obtain instruction in the lab. 106 weeks. Then, who is appearing for whom? Mr. Datta has accepted notice.
1, 4, and 5.
1, 4, and 5. Miss M. Bhattacharya for respondent number 2 and Mr. R.K. Talukdar for respondent number 3. Service of notice is being complete in this case. Extra copies. May 8 weeks will see. Extra copies.
Item 13.
May I please, your lordship? I am for the plaintiff, your lordship. Petitioner. I am for the petitioner, your lordship. Your lordship.
Are you a counsel?
Yes, your lordship. I am arguing counsel.
Then why are you not in your attire, court attire?
Your lordship, yesterday I met with an accident and I could not wear the jacket, your lordship. It has been various injuries on my legs, hands and legs, so I could not wear the jacket, your lordship. May please pardon, your lordship. Yesterday night only I had met with an accident, your lordship.
You are arguing from where?
Your lordship, I am in Delhi right now. And your lordship, this is the petitioner, is a government servant, your lordship. This is a case challenging the office memorandum dated 6th October 2022, your lordship, on annexure 4, page number 4041.
Lordship, partly it is a challenge to this OM. Now, this OM would be effective if he was posted in the northeastern region and if his family was in Delhi. As it is, Lordship, if I may take your Lordship to paragraph 23 of the writ petition at page 17. He has been posted back to New Delhi on 5/4/2024. And he says that thereafter he applied for regularization of his accommodation, which was done away with by notification of 2022, which says that the benefit of this retention of the what was in the previous place was not applicable. Now, his only grievance at this stage would be the regularization of the rent that he has paid. And Lordship, he says that he has prayed for his regularization, which was rejected. It is not annexed in the petition, Lordship, not the prayer, not the rejection order. So if his challenge is only to the notification, to that extent, it is only.
Where is the application for regularization?
It's not there, Lordship. It's not there.
Yes, Mr. Counsel, where is the application for
Your
regularization?
Lordship, the petitioner has time and again applied to the concerned department for the regularization, but they have not give any heed to it. Even
Correct.
he has given.
Where is that application for regularization?
Your Lordship, I have sent this document earlier, so I could not place that application. I will file in a supplementary affidavit, Your Lordship.
File it, then we'll see.
Your Lordship, Your Lordship, please, may I submit?
Hmm.
At this time, Your Lordship, it is very difficult for the petitioner to stay in a place where he is residing. Actually, as per his entitlement, he is entitled for a bigger quarter, and due to the pending telescopic charges for the time being posted in the Northeast region, he has been not allowed to apply for the entitlement.
And that
Entitled
is to
quarter.
bring on record, Lordship.
Please, Your Lordship, he is a government servant. He is not going anywhere. At least as an
Counsel, you bring me your documents on record. Who is the local counsel here?
Your Lordship, it is Mr. D. Banerjee. He's not in a court right now. He is out for some
On the
personal
prayer
work,
of
Your Lordship.
Petitioners Council, who has addressed this course through remote VC, this matter stands adjourned so as to enable you to file an additional document, bring the relevant additional affidavit, bringing the relevant documents on record. Register to list the matter again for motion as soon as the additional affidavit is filed. Mr. RKD Chaudhary, learned DSGI, is present on behalf of the respondent. You file the additional affidavit, then we'll consider.
Yes, Your Lordship. Please, may Your Lordship, please allow interim prayer. At least no coercive action will be taken against him.
File it, file it. Yes, next matter. Next matter.
Maybe before. My lord, this regarding my lord, scale pay, my lord, notice may go, my lord. NGO of
The petitioner is working as Kendra Sahayika.
Yes.
She is seeking higher.
Yes, NGO of the judgment, my lord, laid on by this court, my lord, in writ appeal, my lord.
Which is the judgment?
Judgment, my lord, page, my lord, I have annexed, my lord. Page 26 onward, my lord.
Page 26.
Yes.
Yes.
Relevant
Part
portion
you are
may be page 26, 37, my lord.
Which is the relevant part?
37, my lord. Bharat 22, my lord. Bharat 23. 22 and 22. Admittedly, I'm master worker, my lord, master role worker, my lord. And the judgment include MR workers also, my lord.
All right, we'll issue notice at this stage. We'll say heard Mr. Solicitor Counsel for the and Counsel for the petitioner. You are there in this case. Are you there in this case?
Yeah, I think you're.
Huh? Relief petitioner hearing was temporarily appointed as Kendra, Kendra Sahayika, Sahayika. In a Ratia Daha Aided Center. Is it called Ratia Daha?
Yes, my lord.
What is the name?
My name, my lord. Appointment letter, my lord. Annexure 2. Annexure 2 is the appointment letter. Page 17, my lord. Since 1987, I have been working, my lord. My name is serial number 17, my lord. Dipti Rani Devi. Srimati, my lord.
In the, so and so in the Chapar Family and Child Welfare Project, Dhubri. It is in Dhubri.
Yes, yes.
So you have written something else? You have written it is in Golakganj.
No, presently, my lord, I'm posted here, my lord. Annexure 2, my
The
annexure
petitioner was
1.
temporarily appointed as Kendra Sahayika in a family child welfare project at a fixed remuneration. First of all, at present,
And the respondent number.
the petitioner is attached to the Office of Child Development Project Officer, bracket CDPO, bracket close, Chapar dash Salkocha. Full stop. Claiming that as per the judgment and order passed by the division bench of this court dated 8/6/2017 in the case of State of Assam and others versus Upendas and others, Upendas and others, citation. The petitioner is entitled to the minimum of pay scale since he has completed more than 10 years of continuous service as a casual worker. The present writ petition has been filed seeking a writ of mandamus. Full stop. Who is appearing? Ms. J. Gogoi, learned standing counsel, Social Justice Department, Social Justice and Empowerment Department, Assam, appearing for the respond numbers 1 and 2, and Ms. M. Bhattacharjee, learned additional senior government advocate, Assam, appearing for the respond numbers 3 and 4, have both prayed for some time to obtain instruction be made. NOMC 8 weeks since the respondents are already represented, no formal notice, extra copies, etc. etc.
Applies, my lord.
Item 15.
Matter pertains of appointment on compassionate ground, my lord. The DLC rejected, my lord. Page 78.
What can be done? Dismissal and admission stage.
My lord.
The matter pertains to claim of the petitioner for appointment on compassionate ground. It appears that the petitioner's father died in harness on 14/3/2005 and the SLC had rejected. SLC had earlier rejected the candidature of the petitioner for appointment on compassionate ground due to late submission of application. According to Mr. Padgiri, Chair Padgiri, learned counsel for the petitioner, the SLC was not correct in rejecting the application of his client. The learned counsel for the respondents have questioned the maintainability of the petition by contending that no writ of mandamus can be issued in favor of the petitioner at this point of time. The departmental counsel have also prayed for some time to seek specific instruction for making further submission in this case. In view of the above, NOM 8 weeks, your for?
BTC.
567 BTC. Respondent 567.
CS American and GA Assam has accepted notice for respond number 1
And 3
and 3. Mr. D. Gogoi, learned standing counsel, Forest Department, Assam for respond numbers 2 and 4, and Mr. Mushari,
567.
learned standing counsel GPC for respond numbers 5, 6, and 7. As such, service of notice is complete. Scale extra copy of the information.
Item 16.
May it please your lordship. My lord, petitioner before lordship, my lord, has challenged the legality and validity of the selection committee, my lord, constituted by the Tesco University, my lord, for selection of the post of deputy registrar, my lord, the Tesco University, my lord. Which was,
So your client appeared in the interview.
yes, my lord.
And
After appearing in interview, he has noticed that some members, my lord, who were present in the interview, my lord, they were not as per the
so when did he appear?
14 years, my lord. My lord,
14/9.
on 14 my lord.
14/9.
And when was the 14/9/2024?
24.
When was the result declared?
Result, my lord, recently petitioner came to note that the respondent were 12, my lord. he had to join the, let's say, post, my lord, recently, my lord, after filing of the.
After that, he has challenged.
No, my lord. Before he had joined, my lord, I have challenged.
Oh, after appearing in the
Yes,
interview,
yes,
did
my
he
lord. Yes, my
immediately
lord. Yes, my
challenge?
lord. Yes, my lord.
No, he has not, he has come to this court. He has not filed any representation.
This was there, my lord, but in fact, my lord, after appearing, he had noticed that some members, my lord,
Yes,
who were
yes.
present, my lord.
So he had noticed it on 14/9/2024.
My lord,
Then thereafter, what did he do?
my lord, he had approached this court, my lord.
Then we'll dismiss it. You finish your arguments. Conclude it. I'll give you 5 minutes.
My lord, in fact, my lord, he could have filed representation, my lord, but subsequent, my lord,
You want it to be dismissed or you want to withdraw and file representation?
my lord, we will file representation, my lord.
Mr. S. Hotline, counsel for the petitioner. After arguing the matter for some time, seeks leave of this court to withdraw the petition to file appropriate representation before the Vice Chancellor of Tezpur
This will
University.
receive, my lord.
The prayer is not opposed by Mr. S. C. Kyle, counsel appearing to the respondent. In view of the above, his writ petition stands dismissed on withdrawal with liberty as per.
My lord, I am obliged.
May it please your lordship. Lordship, this is regarding appointment for staff selection commission, lordship. It is a case where the petitioner who was found to have requisite height in an earlier recruitment process conducted by staff selection commission have been disqualified this time.
You obtain instruction, will issue notice. Is it 2023?
Yes, let's say.
Lordship,
Ask
this
Mr.
is for
D.
2024, lordship, and the PET PST is still going on, lordship. And there is one similar order,
Similar
lordship,
order
from
has
this
been passed.
honorable court. Lordship, it is at page 67. And at page 71 is the Lordship, may I read? At page 71, paragraph 8, Lordship.
So how many petitioners here?
Only one petitioner, Lordship.
So you want a similar order?
Yes, Lordship.
This appeal is permissible under which provision? Appeal under which
Yes.
provision?
Appeal on the PET PST only.
A provision.
Okay. Provision,
Appeal cannot be filed unless there is a provision under the law. That's why similar orders need not necessarily lead to similar outcome.
Lordship.
You show me the provision which allows an appeal to be filed. Otherwise, no question of appeal.
Lordship, but there is this similar order. In fact, there is an order from this honorable court, Lordship.
Which is the provision which permits an appeal to be filed? If there is no such provision, this court will not pass that order because it is not a correct order. Then you have it before that court.
No, Lordship. In that case, Lordship will issue notice, Lordship.
No, without a appellate provision, how can there be an appeal?
Lordship, I'll bring that provision in the next day, Lordship.
Huh?
Let it come after
right.
2 days, Lordship.
Mr. D. Dekal, counsel for the petitioner, prays for posting this matter again after a week for motion so as to enable him to examine the legal issue and address the court. Prayer allowed. Ms. S. Borua learned CGC appearing to the respondents to also verify and appraise this court if there is any provision for preferring an appeal against the rejection of candidature of the petitioner under the rules. List this case accordingly. You don't point out that there is whether there is any provision of appeal or not. What do you do before the court? How can there be an appeal filed without a provision of filing appeal?
Maybe provision is there.
Huh?
Provision is there, but
What is it? You show me.
Yes, I have to bring.
You don't know, but you are not. Yes.
Item 18.
My lord, another matter, my lord, it's on next week, my lord. Along with that matter, my lord.
As paid for by Mr. K. Patgiri and counsel for the petition.
5271.
Matter stands adjourned. This case along with WPC number
5271.
5/7 of 2024. Ms. L. Borwal, I'm a CGC present on behalf of the respondent.
I don't like it.
May it please your lordship. My lord, the petitioner before your lordship is serving as deputy manager. My lord, he was appointed on 18/6/2014. And my lord, he submitted his particular in the attestation form 4 in numbers. Now,
What
one
is the order dated 13/1/2020?
That my lord, by that order, he was exonerated.
Where is that order?
Yes. 15
Page number?
Just 1 minute. Huh? Just 1 minute. My lord, your lordship may kindly come to the operative part at 124.
124.
124, considering all the above,
These are not legible also.
considering all the above, the charges cannot be proved in the prevailing circumstances, and therefore, in exercising the powers conferred under rule so and so, so and so, the undersigned has decided that no penalty should be imposed against so and so, and he should be exonerated. Thereafter, my
And
lord,
what was the charge against the petitioner?
my lord,
That-
charge is, my lord, that he has given a false information regarding his experience certificate is totally a false one. And
Where is that finding in this, the charge, about the charge?
yes, that melody, your lordship will have to see at 399. Melody, your lordship may see now at page 123. Last but second, my lord. Now therefore, after considering the charges against the so and so deputy manager, the findings of the facts and circumstances of the case, the undersigned come to the conclusion that on account
I'm
of the
asking what is the charge? You are saying what is the conclusion
melody,
of
your
the charge?
lordship want to see the charge.
Yes.
Melody. That your lordship will find it. দাঁড়াও না, অস্থির হচ্ছে কেন? Page 99, my lord. Your lordship may come to page 100. As per the declaration from there.
Yes.
As per the declaration in attestation form given by Shumit De at the time of joining BCPL, he had worked in Messrs. Cummins India Limited from 4/7/2011 to 7/5/2013 and Messrs. Reliance Industries Limited from 8/6/2013 to 10/7/2014. He has also submitted photostat copies of experience certificate of all the above organizations. Based on his clarification, and the above experience certificate were forwarded to the concerned organization for verification at their end. Messrs. Cummins India Limited, in response to the letter dated bearing number so and so, verification of dated 13/8/2014, replied by email dated 22nd September 2014 that there is discrepancy in the service certificate that Sri De has provided to BCPL vis-a-vis one that Cummins has issued to him. Messrs. Cummins India Limited stated that they have issued the service certificate to Sri De on 7th November 2012, whereas the certificate that he had submitted to BCPL has the date 7th May 2013. They have also stated that Sri De's date of living was 5th November 2012, which is mentioned in the service certificate issued by Messrs. Cummins India Limited, whereas the certificate submitted by Sri De BCPL, the relieving date is mentioned in 7th May 2013. Further, they have also communicated that there is also mismatch of the signature in both the certificates and have also enclosed the certificate they have issued to Sri Dev, which has
been signed and acknowledged by him. Now, the main issue your lordship will find, my lord, your lordship will find when I filed the 4 attested form, my lord, they have lost the hard disk of the 3 computers along with my service record, they have lost it. And after that, what they did, they filed a criminal case against me. They could not prove the criminal case. I was acquitted. Thereafter, they fall back to the departmental proceeding. And the main issue is, my lord, the original certificate which the Cummins India given, rightly, my lord, I have worked up to 5 November 2012. And that is the certificate I have given, they have lost. Now, in 2017, if all these attestation certificate has been lost, where from they get the 2017? And in the 2017, all manipulation was created by the management. And ultimately, they could not prove it. My lord, I was exonerated in the, my lord, departmental proceeding. Then after 2.5 years, they filed a review application. Review application, what they did, they have imposed a my lord, penalty of censure. Now we have filed a censure. So we have filed a writ application before this honorable court, which is pending. Now on the same set of charges, they are the player of the words. By changing some words, your lordship kindly see the memo which your lordship will find at page 169.
So it is writ petition, what is your prayer?
My lord, on the same set of charges, when already I have been exonerated, my lord, by using the words, can they start a fresh charge sheet against me on the same sort of incident? The law is very clear on that subject, my lord. Now, I want, my lord, this proceeding, my lord, so far the charge sheet they have issued, on the basis of that, the inquiry should not be gone into, and your lordship may interfere at this stage. This is my prayer. Now, if I take your lordship, just a, my lord, judgment of the appeals court is also there, but very, my lord, specific judgment of the Madhya Pradesh High Court. My lord, I will just read 2 paragraphs.
What is the point? What is the point?
My lord, point is this, my lord, just 2 lines I will read. The impugned charge sheet came as a bolt from the blue to the petitioner. The second charge sheet for the same incident is bad in law. The respondent cannot split the charges, frame new charge on the basis of the same incident, and subject the petitioner to another inquiry. And the paragraph 11 is more clear. The only question needs determination is whether the department was justified in somewhat changing the nature of charge using different language and thereby can subject the petitioner to another disciplinary proceeding for the same incident. But exactly this thing happened in this case.
Which is the other writ petition pending?
That is, my lord, 6731 of 6371 of 2022.
Of 2022.
My lord, actually facts is that this is, they are trying to make out a case of double jeopardy. This is not a case of double jeopardy. What happened, my lord? First one, first charge, why the charge has been levied against him, and for that he has been exonerated later on. Censor has been because he has given a false certificate regarding the age, experience certificate. After that, what happened, my lord? They have filed a writ petitions, 2 writ petitions, one for regulation of service and one for challenging the censor, and both are pending. They want to withdraw. After that, when they filed the second writ petition, we have just compared the attestation form of both the certificate, both the writ petition. We have found some anomalies. In one writ petition, they have filed one set of certificate and an attestation form, and a second one they have filed a different set of attestation form where there is some anomalies. So we have filed an affidavit. When I file an affidavit, they want to withdraw the first one. I just raise an objections before this honorable court. This honorable court says, no, we will not allow you to withdraw this case unless the second one is disposed of. So after going through all these 2 facts, attestation form, we have come to know there's some anomalies. So we have tried to find out from the district magistrate, Jabalpur, that what is the facts. So when we file a and we have sent a attested form to verify. We find that there is a different, altogether different anomalies. They have found another, the report which we have come from district magistrate is not similar or familiar, which one they have filed before this, which is in our custody of BCPL. So if I go to the second charge, 171.
So
my
Mr.
lord.
Mitra will issue notice, stay further proceeding till you file your affidavit.
No, my lord, further
And you can
proceeding.
argue on that, but that order I am passing.
No, my lord, our further proceeding means already Departmental process started. Two sitting has already made.
We'll stay it.
And they have filed a written statement also. They have filed a written statement. And they are
We have to
yesterday
examine
also.
Once this plea is raised, it has to be
No,
examined.
my lord, my thinking was, let it do it at a very initial stage. Is not not yet be right also. The departmental proceeding will find out whether the inquiry committee will find out whether there is an anomaly. We have not said that there are no second charge
No, the issue is about maintainability of the next proceeding.
maintainability of the writ petition.
So how can we allow it to go? Heard Mr. S. Dattal and senior counsel, instead by Mr. S. Dattal and counsel for the writ petitioner. Also heard Mr. S. Dattal, and standing counsel, you are standing
BCPL.
BCPL assisted by Mr. S. And counsel for the respond numbers
2 and 3.
2 and 3. Mr. S. Gill and CBC has reported on behalf of the respondent.
So, my lord, what standing counsel has to be omitted because they are under process. I'm not yet been appointed as standing counsel.
Then
But I'm
how
the
has
counsel.
they appeared?
I'm the counsel.
You
I'm
filed
the counsel.
wakalatnama?
Yes. No, wakalatnama, they have given authorization, telephonic instruction to appear.
Your clients cannot change the rules of the High Court. If you are not standing,
No problem.
if you are not standing counsel, then we not record your presence.
No, if it, we don't, no
You
problem.
cannot appear like this.
Yes, my lord, I know.
Either you are a standing counsel or you have to file your wakalatnama.
I will file wakalatnama today.
File it.
My lord.
Because we have to issue notice to your clients now.
Okay.
You understand the?
Yes, I know, I got your point. No, he's with that standing counsel because they may write.
That's all right.
Uh,
If you are not the standing counsel, then it's bad for your clients, but then we cannot accept your arguments. You are not authorized.
not authorized. That's right. That is the
The
thing.
law is very difficult. You know it.
I know.
Legal issues are difficult. What authority you have to argue?
Mail authorization is there.
Huh?
Mail authorization. Mail authorized.
No, have you filed it?
No, I have not filed it. Yesterday already I have received that mail authorization.
No, at best,
And there's some copy on me also. That is the thing.
My lord, he posed himself to be the standing
No,
counsel.
not post.
What can
Why
I
you
do?
said like post?
Yes, sir,
Because
what to
every
say?
BCPL case I have been appointed.
My lord, I can tell your lordship, he has stated certain things, these are not factually correct. My lord, I can say that everybody has a right to be opinion, but nobody has right to be wrong, right to be, my lord, he cannot make a wrong submission before your lordship. Ultimately, what happens? My lord, the cause of justice will suffer. We are to assist your lordship. What he is doing here?
that is correct. That's why I thought he was the standing counsel.
When even I thought it, because the last time also he told me I'm
No,
standing
because
counsel.
every cases I have
Don't
been
say no,
appointed.
no.
No, I'm telling
You are a
that.
pretty senior.
I'm a standing counsel of GAIL India Limited. Since that it is
He
sister
used to
counsel of
give that
BCPL.
impression.
He is
Alright.
since it's a sister
Alright,
counsel of BCPL. So
Listen,
GAIL has authorized BCPL to appoint him as a counsel.
Mr. S.K. Metin, our counsel is CBC has appeared for the respond number 1. Mr. S. Mitchell, our counsel, submits that although he has received telephonic instruction from the respond numbers 2 and 3 to appear in this case, since the wakalatnama is yet to be filed, hence he would not make any submission on the merit of the case today. Full stop. The case of the petitioner reduced to its nature, reduced to its essence, is that having the authorities having exonerated him by the order dated 13/1/2020 in respect of charges framed in a disciplinary proceeding, have now issued the impugned order dated. What is the impugned order date?
7/6/2020. 24 at page 169.
7/6/2024, initiating a fresh departmental proceeding on the same set of charges, thus exposing the petitioner to the risk of double jeopardy of facing penalty under the law. Full stop. According to Mr. Datta, learned senior counsel for the writ petitioner. Although the charge brought against the petitioner in the subsequent departmental proceeding initiated while memorandum dated 7/6/2024 is what?
7/6/2024.
It's the memorandum of
This is the
charge.
memorandum, and the next page you also will find at page 171. The article of charge.
Memorandum dated 7/6. What have you written? Submit that. Submit that. Is one and the same as that involved in the departmental proceeding, which ended in the order of exoneration dated 13/1/2020. Yet merely by play of words and by uh, uh, merely by play of words and distorting the facts, the second proceeding has been initiated, notwithstanding the fact that the order of censure imposed upon the petitioner in the earlier round itself is under challenge in WPC number 6371 of 2022, which is pending disposal before this court. Under the circumstances, the learned senior counsel for the petitioner has prayed for an interim order of protection until such time the writ petition is disposed of. Full stop. After going through the amendments made in the writ petition as well as the documents annexed thereto, this court is of the opinion that the petitioner has made out a prima facie case for interference. As such, issue notice of motion returnable on 9/12/2024. Since the respondent number 1 is already representing, no formal notice is required to be sent to said respondent. Petitioner takes steps for service of notice upon respondent numbers 2 and 3. However, subject to furnishing of Wakalatnama, Mr. S. Mitra would be entitled to receive copies of the Wakalatnama within a week from today. Mr. S. Mitra and counsel would be authorized to accept copies of the writ petition on behalf of, accept notice of writ petition on behalf of respondent numbers 2 and 3, in which event no notice by registered post with AD need be sent in this case. First step. Heard on the prayer of interim relief, the said prayer will be considered on the returnable date. However, for the ends of justice and as an additory measure, it is hereby provided that further proceeding in the departmental inquiry initiated by memorandum dated 7/6/2024 shall remain suspended till the returnable date. The respondents may bring the stand on record by filing affidavit on or before the magistrate fix if so advised. Registry to list this case again along with WPC number 6371 of 2024.
Well, my senior counsel has pinpoint my conduct, my lord. In one case,
I'm not pointed out about the conduct.
I'm not appearing. I
I
just
can-
want to appear, my lord.
I can only
He
say he
said
has given us the
that
impression.
My learned friend submitted before the court that I am avoiding to receive the copy and is it is against the public.
All right, if you are not the standing counsel, then Mr. Mitra, you should not have appeared today.
No, because I would.
You are exposing yourself to these difficulties. You are also a pretty senior counsel, no?
Yes, my lord.
Unless you are properly authorized, you should
No,
not
because
appear.
mail authorization is that's the only mistake is that I have not filed.
Mail is the matter between you and your client. How is the court concerned? You should not have appeared if you are not a standing counsel. You have invited this petition for yourself. If you want your honor, your prestige should be protected. It's not about you only. Then all of us will have to be careful about our conduct. We cannot do things and then complain about the consequences. As a counsel who has spent such long years in this profession, how did you appear in a matter where you are not authorized to?
Because I was.
That is none of the business of the court.
Yes, madam.
You can only appear if you are a standing counsel or if you have filed wakalatnama. Why did you appear in this case and make submissions? You should have said that I have instructions to appear, but I will file wakalatnama. Beyond that, you can't make a submission. So what you did is a way of misconduct. I'm sorry to say.
And my lord, for this sort of incident, I can tell your lordship, the entire fraternity gets a bad name.
Mr. Mitra, you have to be, you invited this comment from the court. You invited, don't get further into it. You should not have appeared. You are not a young 5-year-old practitioner. You spent decades in this system. You know, if you are not properly authorized, why are you appearing for the client and making arguments?
You received the court.
That means you have a personal interest in the matter.
No, I am not.
Oh, we don't know.
You ought not to have received the
You
court.
can't. You can't appear.
No, last time also I did.
You
I did
cannot
it.
appear. Last time we are not concerned. When I record your name, you are saying you are not authorized. Or you could have said that posted on Monday, I'll file wakalatnama. You don't do anything. You start making arguments on law. And then when he retorts, then you are sentimental. You have to understand this is a court proceeding. The judges will have to follow certain code. Why do you invite these comments and invite this embarrassing situation? You have to be careful yourself if you want that your honor and prestige should be protected. Will any lawyer of your standing appear in a matter without being duly authorized?
No, that I don't.
You could have only said that give me, post it on Monday. In the meantime, I'll file wakalatnama. Beyond that, you can't make any submission here. Instead of doing it, you start arguing on merit. What kind of a conduct is this, Mr. Mitra? Can you explain your conduct? On what basis you have taken the court's time? If I ask you that, what answer will you give? You have to be careful. You have to be careful. Otherwise, it will lead to unpleasant situation. I don't want to make any comment here and there, but just because you have raised this issue, I'm saying it as a matter of clarification.
Yes.
That you have to be careful yourself if you want your honor and dignity to be protected. Anybody, whether it is a counsel in the bar, whether it is a
which I will take.
judge deciding the matter, everybody has to be sober, decent, within the limits, as follow the norms which is required to follow, then there is no problem. Moment people act in violation of such norms, somewhere or other there will be problem. And then once an incident happens, an ugly incident happens, then things take a bad turn. So all I'm trying to say is that we have to all act very responsibly. If your client says, go and make a submission, you should have scolded them. You are the one who will tell them what is the rule of the court. Rather, you are telling the court what is the rule of your client. I don't say all these things, but is it not incorrect, improper on your part? Can somebody appear on an email? You want to appear in this case? That means you are allowing your clients to set the rule for the court. Think about it. Think before you say. When you think before what you say, when you follow the norms, there is absolutely no problem in our system. There is no bitterness. There is no. Ultimately, everybody is doing he is doing his job. You are doing your job. Is it not? These are all professional work. I am as a judge doing my job. We don't have any personal involvement. But once we act in violation of the norms, then it becomes a personal matter. And that is when the problem starts. So please think about it. I'm just pointing it out because a lot of junior lawyers are here. Tomorrow they will grow up. They will have to manage this system. This consciousness has to be there. This is a beautiful system we have. Yes, we have to protect it. If we have to protect it, we have
I will
to
tell my client. I will tell my next time. Yes.
You are the officer of for your client. You are the representative of the court. You have to tell him that this is not the way. You send wakalatnama by tonight, or else I will not appear. That is the strength you have as a lawyer. Instead, you are succumbing to what they are saying. I am sending an email. You go and appear. See the difference. That means you are falling in line with what they are saying, not what, this is your institution. Anyway, please don't mind.
No, I'm not. Hey, I should learn
Nothing
also
against,
from my
nothing
person.
against anyone.
No.
Since the issue cropped up, I thought I will just clarify that these things are avoided if people stick to the norms. Anybody. And I'm also including a judge presiding a court proceeding who is equally duty bound to follow the norms, equally duty bound. It's not that only the members of the bar. A judge is also equally duty bound to follow the norms. And if everybody follow the norms, we will have this
no problem.
beautiful system running without any. Let not others dictate what we do in our court. You can say, I can decide, you can say, but don't let others dictate. This is our institution. We have to protect it. Best wishes. Yes.
Your lordship is very rightly said, because afterwards, my lord, the younger generation will inherit what we do. So therefore it is needed.
That's right. It is our institution.
No, we should preserve our institution.
You and we make it together. If we do not protect it, we do not maintain the sanctity, we dance to the tone of clients, tomorrow it will completely go out of control. If the client makes a unreasonable, you tell him that this is not the way. In our system, we operate like this. You have to follow it. But instead of doing it, if we do whatever they ask and giving a go-by to the norms, they will be diluting our own system.
Yes.
Future generation will suffer.
No, it will be good for me also, because they are also watching and they will understand what
this
this
is
court
not
will
correct.
think. Yes, I will tell them, definitely. I will
There is
tell
a
them.
provision in CPC. Look at Order 7.
Yes, I know.
You cannot appear unless authorized.
Yes.
Except if you are arguing for yourself. If you are the client.
Yes.
The client can appear, but a lawyer cannot appear without being duly authorized. You cannot make your submission before the court. That means you don't have the instruction. You know the consequences of making submission before the High Court without being instructed. I don't want to go that far. Think about it. Think about it, what happens when you make arguments on facts without being instructed. Look up the Bar Council rules and see.
Yes, I can.
All right, next matter. But please don't take anything personally.
No, I'm not. Why I should take.
Idea is not to.
No, it is very
encourage
good that
anyone.
it should be
But
clarified.
there are times when we have to speak up.
Okay.
May it please the court. For the disciplinary proceedings against me, but the witnesses and the complainant are not being allowed to cross-examine. Number one. That is firstly. And secondly, my lord, they set up a trap team against me. Trap team for acceptance of bribe. They say I've accepted bribes. The trap team members are not even the witnesses. In the criminal case, they'll be using the same set of witnesses against me without arraying them witnesses here. First part. And the second part is that the two bank officials, I don't know why, they've arrayed as a witness. I'm not being allowed to cross-examine them on both two counts, my lord.
File representations before the authority. If they don't agree and pass an adverse inquiry report against you, we'll set it aside.
That's all.
Nothing can be done.
No, that's all. I'm
You
not
want
even
to
praying for
withdraw?
more than. I'm not even praying for more. Thing is that now the stage
No,
is.
you are not praying. You can't pray for anything.
Basic.
You
No,
can't pray
I'm
for
not even
more.
on
You
that
can't
far.
pray for less also.
So we wanted the thing to be appraised to the honorable court so that things which are going in the manner against me.
You appraise them. Keep the record.
Very good. Very good.
And when if something goes against you,
Lordship.
then you point out.
Lordship, absolutely.
You want to withdraw and agitating your
Lordship,
then we'll
I do not-
dismiss. If I dismiss, you cannot agitate this point.
I understand. We have taken a plea, my lord, that they are not allowing us to cross-examine the witnesses.
Pursue it. Pursue it before the authorities.
That liberty be granted. my lord.
Yes.
That liberty be granted.
Yes.
That
We'll grant him that. But if I dismiss it, you can't take that plea.
that liberty be granted.
Mr. Vanek, unfortunately, law is technical.
And
Otherwise, anybody would come. With
9/6 violation of 9/6.
Otherwise, instead of a petition, a WhatsApp message will do. Why do you need lawyers to draft petition and pay thousands of rupees?
Therefore, we have
Because
taken,
it is technical.
therefore we have taken a plea of 9/6. That without
Plea of
9/6 of the rules, rule 9 sub rule 6,
Yes.
where I've got the right to cross-examine.
This is not a civil CPC
No.
civil proceeding.
Under the extant rules, I have a right to cross-examine the
You
witness.
agitate it before the authority. If they don't heed to it, then this is a violation of the safeguard. That will vitiate the proceeding. Why should we
That
interfere
liberty
at this
got-
stage?
That liberty on this count.
Mr. S. Banit, Learned Counsel for the petitioner, has argued that the departmental proceeding initiated against his client has been conducted in violation of procedural safeguards as well as principles of natural justice, inasmuch as his client has not even been allowed to cross-examine the witnesses relied upon by the department. Full stop. Mr. D. Gogoi, Learned Standing Counsel for the Forest Department, Assam, submits that since the departmental proceeding is yet to be concluded, it will always be open for the petitioner to agitate his grievance before the authorities at this stage. Similar is the stand of Mr. C.S. Hazarika, and a government advocate. You are there in this case?
He's not there.
Yeah, there. Just a- After going through the materials on record and after hearing the submission of the petitioner's counsel, this court is also of the opinion that at this stage, no interference with the departmental proceeding is called for. The grievance expressed by the petitioner can be raised before the inquiry officer. Full stop. In the event such grievance is not redressed in accordance with law, the matter can always be examined by the court at an appropriate stage, if and when the occasion is. Therefore, by granting liberty to Mr. Banit to agitate the grievance of the petitioner before the inquiry officer, this petition stands closed.
Online.
Item 21.
May it please your lordship. Lordship, these petitioners here are contractual employees of ASMA working for 10 years, more than 10 years. So as per the judgment of Upendas and Jagjit Singh, they should be getting their minimum pay scale. However, they have not been rendering their minimum pay scale, and that is what I've been praying for, man. My lord, I've been even given the pay slip and the amount they should be getting, even despite of giving several representation to the authority, their prayer has not been answered to.
Will issue notice.
Yes,
of
my
this.
lord.
How much time you need?
3 weeks. Lordship.
3 weeks.
Instruction.
Ah.
Lordship, next week.
No, you file affidavit. Or you obtain, I'm issuing notice.
My lordship.
Because there are a lot of cases of this nature. I heard Mr. S.P. Sharma, Learned Counsel, appearing for the petitioner. The petitioner here is claimed to be serving as grade 4 contractual employees under the Assam State Disaster Management Authority, bracket ASDMA, bracket close, and have, full stop. According to the petitioners, they were associated with the ASDMA since its inception, that is in the year 2011, and in this manner, they have rendered more than 10 years of continuous service as contractual employees. Mr. Sharma submits that as per the decision of this court in the case of State of Assam and others versus Upendas, reported in so-and-so, the writ petitioners are entitled to the benefit of minimum pay scale as well as other service benefits as made applicable to similarly situated employees by the decision in the case of Upendas Supra. As such, a writ of mandamus has been prayed for in this case. Mr. S. Datta, Learned Standing Counsel, appearing for the Revenue Department, and Mr. C.S.
3 and 4 I'm.
Learned G. Assam have both prayed for 4 weeks time to obtain instruction. Prayer allowed, issue notice of motion returnable in 4 weeks. Since Mr. Datta has accepted notice for respond numbers
2, 3 and 4.
2, 3 and 4, and Mr. Hazarika for respond numbers 1 and 5, is it?
1, 5. Only one.
Hazarika 1, so Datta has 2, 3 and 4. And service of notice deemed to be complete in responding to upon respond numbers 1 to 2. Extra copies of the writ petition, requisite numbers, will be furnished to the Learned Department Council. Within a week from today, petitioner will take steps for service of notice upon respond number 5. Make it 6 weeks then.
Lordship.
By register post it daily.
Item 22.
May I please, your lordship? Petitioner was the cell attendant of the Artfit Akhodia, my lord. My lord, petitioner was suspended due to FIR and his arrested, my lord. My lord, Honorable High Court granted bail on 16/6/2024, my lord. My lord, impugned suspended order is annexure 13, page 45, my lord.
So your grievance's order of suspension has not been revoked.
My lord.
My lord, suspension is issued by respondent number 2, my lord. I am not appearing for respondent number 2. I am for 1 and 3, my lord. The department, my lord. Here, my lord, notice has to go for this respondent number 2.
So who is the respondent number 2?
My lord, impugned order is page number 45. The second. Page number 45, my lord.
That is not your organization. Respondent number 2.
No, my lord.
You are not connected.
No, my lord. We just give them granting aid. Maybe that's why they have made us.
Notice has to go then.
Notice has to go, my lord.
Heard Miss
L. Burwa.
L. Burwa and counsel appearing. The petitioner here is serving as sales attendant under the Assam Apex Waivers and Artisan Corporation Federation Limited. Full stop. Agreed due to the petitioner was placed under suspension by order dated 25/6/2024 due to his arrest in connection with Sadia PS case number 9 of 2024, registered under section 409/420 of IPC. Although the petitioner has subsequently been released on bail by order dated. What is the bail order date?
Bail order dated 16/6/24.
When was he released on bail?
16/6/24, annexure 12, my lord. Page 42.
16/6/24.
24.
24. Yet the authorities have neither reviewed the order of suspension nor revoked it till today. Hence the petition. Issue notice returnable in 4 weeks. Since Mr. R. Dhawal, understanding counsel, Handloom and Sericulture Department, Assam, has appeared in accepted notice for respondent numbers 1 and 3. No formal notice is required to be sent to the state. We'll make it 3 weeks, sir. 3 weeks. State respondent, extra copy of the writ petition be furnished to Mr. Dhawal within 3 days from today. Petitioner to take steps for service of notice upon respondent number 2 by registered post with AD. Within 3 days from, you take it within 3 days.
Yes.
Try to do it today itself if possible. 3 days from today. Heard on the prayer of interim relief. The said prayer will be considered on the returnable date. You want a fixed date? Do you want a fixed date?
Yes, ma'am.
When do you want it? After 3 weeks?
Any date, my lord.
Huh?
Any date, my lord.
14th November. Returnable on 14th November.
My lord, subsequent allowance of the petitioner was not paid, my lord.
It is, however, made clear that if the petitioner is still continuing, if the petitioner is still under suspension, the respondent shall take necessary steps for releasing subsistence allowance payable to the petitioner under the rules without any further delay.
Item 23.
In this case, this happened after the death of the father, petitioner, for compensation of family pension. Here, as per rule, it is page 27 notification.
All right, we'll issue notice that
Yes, ma'am.
heard Mr. H. Das, Learned Counsel for the petitioner, the prayer of the petitioner is for payment of compassionate family pension on account of premature death of his father, who died in harness on 19/1/2019. Miss A. Neog, Learned Standing Counsel in Irrigation Department, Assam, prays for some time to obtain instruction. NOM 6 weeks since Miss Neog has appeared in accepted notice.
1, 2, and 4.
1, 2, and 4, and Mr. D. Bhattacharya, Learned Standing Counsel AG, bracket ANE, bracket Lod, Assam. For respondent number 3, service of notice is due to the company. Extra copies of the read petition requisite in numbers may furnished to the learned department council so as to enable them. to-
Deeply obliged.
May I please the lordship? This matter relates to my lord, non-payment of my lord, Bhutan compensatory allowance.
Again, notice as to be.
Right.
Where Mr. J. Sharma, learned counsel for the petitioner. The read petitioner is aggrieved due to non-payment of Bhutan compensatory allowance bracket BCA, which according to him was a foreign allowance payable to the petitioner under the rules. Mr. D. Voral and CGC appearing for the, why state of Assam?
State of Assam is not mentioned, my lord. Typographical error is there, my lord. I'm sorry, my lord.
Cut
I rectify it, my lord.
D. Voral and CGC appearing to the respondents praised for some time to obtain. NON 8 weeks since Mr. Bora has appeared and accepted notice of all the respondents. No formal notice is required to be sent. Extra copies will be required.
Hey, I'm sorry. I'm
Obliged.
obliged.
In this case, we are challenging the input minutes of SLC. Lordship will find at page 39, my lord.
Die in harness.
Yes, my lord.
Shop is closed.
My lord. No, it was,
Shop closed. What to do?
yeah, on last,
You have to
January,
find a new shop now.
my lord.
You have to look for a new shop. You want to look for it now or after vacation? No, no more die in harness appointment is possible.
No, Lordship may kindly see order
All
of,
right, he wants dismissal at admission stage.
no, my lord. Lordship kindly peruse the order of this honorable court passed in annexer Annexer 4, my lord, page 33.
All right. Mr. A. Pal, learned counsel for the petitioner, peruse the statements made in the writ petition. In this writ petition, a challenge has been made to the resolution of the SLC dated
31st December 2018.
31/12/2018, whereby the application of the petitioner for appointment on compassionate ground has been rejected on the ground that 5% quota available for the same purpose had already been filled up. Mr. Paul submits that the impugned resolution is vitiated by non-application of my stop. Questioning the maintainability of the writ petition, Mr. C.S. Hazarika, learned government advocate Assam submits that the state has done away with the scheme for appointment on compassionate grounds by issuing notification dated 18/9/2024. Is it?
Also, I'm checking the date.
18/9/2024, and therefore the relief as paid for in the writ petition cannot be granted to the petitioner. The learned government advocate, however, prays for some time to place the relevant materials on record. In view of the above, NOM 8 weeks since Mr. Hazarika has appeared in accepted notice. Who is for whom? You are appearing for whom?
1 and
1 and 4, 1 and 4. She is appearing for 1 and 4.
1.
Since Ms. S. Sharma, learned standing counsel PWD,
PW.
Assam has accepted notice for respondent numbers 1 and 4, and Mr. Hazarika for respondent numbers 2 and 3. Service of notice is deemed to be complete in this case. Extra copies of the petition are furnished to the learned department counsel so as to enable them to obtain instruction, facilitating disposal of the petition at the admission site.
Also, this is 18/9/2004, 2024.
18/9/2024.
Item 26.
The petitioner is claiming, my lord, she retired from superannuation on 31/1/2024. Page 69 is a release order, my lord. Now 69 is your lordship will find that she was released in the afternoon of 31st January
being a holiday, she was released on 30th of January.
The allegation is
Now-
the Deputy Commissioner has not sent the pension record to the AG. So say I have to get the instruction.
Yeah, I'm coming to that, my lord. Next page, your lordship, page 70. Next page, my lord, the Deputy Secretary to the GAD department has also written to the District Commissioner Kasarman to send the pension papers after her event. But till now, my lord, I also submitted representation. Nothing has been paid.
Mr. B. Borwal, I conflict with the petitioner, parents, the amendments made in the writ petition. The petitioner herein who was serving in the post of superintendent in the establishment of circle officer, Katigura Revenue Circle in the district of Kachar had retired from service on attaining the age of superannuation with effect from 31/1/2024. The grievance of the petitioner is that despite the lapse of several months since her retirement, the pension of the petitioner along with other retirement dues have not been paid till today. First up, according to Mr. Borwa, even the pension papers have not been forwarded to the concerned authority by the establishment of District Commissioner Kachar, as a result of which no action has been taken in the matter till date. First up, Mr. C.K. Borwa, Learned G. Assam, and Mr. C. Borwa, Learned Standing Counsel, appearing for the Office of Accountant General, A&E Assam, have both prayed for some time to obtain instruction in the matter. Issue notice of motion returnable on 18th of November, 2024. Since Mr. C.K. Borwa has accepted notice for respond numbers 1, 2, 3.
Yeah.
7, 8 and 9. Mr. C. Borwa for respond number 5 and Mr. A. Chalia, Learned SC Finance Department, Assam for respond number 6. Service of notice is deemed to be complete in this case. Extra copies of the writ petition be furnished to the Learned Department Council, requisite in numbers so as to enable them to obtain instruction. Register to list this case by reflecting the name of Learned Department Council in the cause list.
For 20 also I cannot appear, sir.
For
For 20 I cannot appear, sir.
2 and 3, who is appearing?
Orunok Fukan, A Fukan.
A Fukan for 2 and 3.
My lord,
Give them copies, all of them.
My lord, for prayer for provisional pension may be considered next day.
The prayer for provisional pension made by the petitioner shall be considered on the returnable date. Parties to come prepared.
Obliged.
No, sir.
Petition is against the transfer order. In the meantime, he is placed under suspension pending report departmental proceeding.
Instructions.
Will likely to be withdrawn in 2 weeks, after 2 weeks, that I will have to consult with the client.
Mr. C. Goswami, Learned Counsel for the petitioner submits that during the pendency of this writ petition, certain developments have taken place as a result of which 10 days time should be granted so as to obtain updated instruction. The prayer is not opposed by the Learned Department Council. As such, let this writ petition be listed for motion again after 10 days.
Obliged.
Item 28.
Pertains non-payment of my lord pension, my lord. It is a otherwise covered case, my lord, retaping number 133 of 2023, my lord.
But
And subsequently the state approached before the apex court, my lord, all.
But even if it is covered, they will have to agree, no? We'll have to give them time to examine.
Yes,
My lord.
and moreover, my lord, after the apex court's order, we are filing today, my lord, one I for clarification something, my lord. From the date from which the pension has to be calculated, my lord. That is why we need some time, man. And that liberty was given by the apex court itself, my lord.
Issue notice, my lord, then.
Yes, notice may be issued.
And Mr. K. R. Padgiri, Learned Counsel for the petitioner, parent the amendments made in the writ petition. The petitioner who has retired from service from the post of Secretary of Gaon Panchayat with effect from 31/11/2021 is aggrieved due to non-payment of pension. First up, according to Mr. Padgiri, the petitioner's case is covered by the judgment and order dated 5/8/2023 passed by the division bench in WA number 133/2023. Whereby a direction has been issued to the government to pay pensionary benefits to similarly situated persons such as the petitioner. Mr. S. Dattal and its standing counsel, PNRD Assam, however, pays for 3 weeks' time to obtain instruction in the matter. In view of the above, issue notice of motion returnable in 4 weeks. Since Mr. S. Dattal and its standing counsel, PNRD Assam, has appeared and accepted notice for respondent numbers 1, 4, and 6, Mr.
Yes, 6 minutes.
C.K. Bobal and Gia Assam for respondent numbers 2 and 5. And Mr. R. Bharpajari and SC Finance for respondent numbers 3 and
7, my lord.
7. Who is appearing for 6?
6 I am appearing, madam.
6,
1, 4 and 6.
1, 4 and 6. The service of notice is deemed to be complete in this case, extra copy of the declaration, etc., etc. Of like.
Item 29.
May I please, Your Lordship? My lord, in the year of 2008, my lord, the petitioner was selected and appointed as SI, my lord, or SI of police, my lord. Thereafter, my lord, their services has been confirmed. And after that, my lord, in the year 2021, they have been promoted to Inspector of Police, my lord. And recently, my lord, they have come to know from a news report that the department has taken initiative, my lord, to remove the petitioner, my lord. Your Lordship, kindly see page 40.
We can't take, but we'll ask them to obtain instruction.
My lord,
What
all-
are 10 days?
my lord, there is a
How
order.
how can they remove you if you have been
In view,
appointed?
yes, my lord. That's why. My lord, there is
We
a.
don't believe your submission and newspaper reporter.
No, my lord, there is a.
Lordship, page 40 is very clear, Lordship. It is stated that the 90 numbers of ineligible candidates were already appointed in the year 2008, along with 49th batch of SI Anam branch without following the recruitment rules properly, Lordship. And there were writ petition also earlier in 2014, order was passed when the Honorable Court has directed to redone the list, Lordship, and accordingly this has been done. And now it is found that the 19 numbers of appointees were illegally appointed without following any norms and procedures, Lordship.
So the petitioners are amongst the.
Yes, this
Yes.
19, Lordship. Already 2 have been removed, 17 remains, Lordship. Today 14 people have come, Lordship.
They have published the select list in the year 2017. After that, my lord, we have been promoted. Our job has been confirmed. My lord, considering the length of service, there is
Where is
an
that order? Where is that order of the earlier order of the court?
earlier order. Your Lordship,
Have you
can
challenged that order?
no, my lord. Your Lordship, can you say Annex 6?
They have done.
What can we
My lord,
do?
Your Lordship, can you say only on the basis of submission that was passed, my lord.
Then if the order is right, then you'll have to face the consequence. If it is wrong, challenge it.
Your Lordship, can you say page 40?
Hmm.
Page 46.
Yes.
The second paragraph, the council appearing for the government submits that the government is reconsidering the select list since the rules regarding roster have not been properly followed. Therefore, the government would redo the selection list as per roster rules. It is also submitted that the persons whose names were not even in the merit list also shown in the selection list. Therefore, the entire select list is to be reconsidered in accordance with the merit and rules. In view of the submission made by the government, the writ petition is disposed of. The government is to redo the select list in accordance with law within 2 months from today. This was passed in the year 2014, my lord. 14. After that, my lord, we have been promoted. Thereafter, my lord, behind our back, the select list was published, my lord, in the year 2017. It was not in our knowledge. 2 of the candidates
Only thing
already.
is they will have to be served notice. That's the only point.
Lordship,
If the notice has not been served, then
Lordship.
No notice was served. In the meantime, my lord.
This,
two of
but
the
Lordship,
candidates-
I also have to check, Lordship.
2 of the
this
candidates, my
particular-
lord, approached the court, my lord. They have got interim order.
Lordship, interim order, I was there on that day because I was unable to trace anything on that day because this was in the vacation bench only, Lordship. So
No,
today I have read the whole thing,
that's all right.
Lordship.
You tell us next week.
Lordship.
Otherwise, we'll stay.
Yes, Lordship.
If they can't be terminated without hearing them,
Lordship.
you tell your clients. Either you show us the notice
Yes,
issue,
Lordship.
but you can terminate them after hearing because they have accepted the order of the earlier.
Yes, Lordship.
Give them a notice,
Considering
terminate
the
them.
length of service, my lord, this interim order
You
was.
have to agitate that order. You have not agitated. But Mr. S. I have Council for the petitioner. Also heard Ms. M. Bhattacharya, learned additional senior government advocate Assam, who prays for time till 29/10/2024, so as to obtain instruction and appraise this court as to whether any notice was served upon the petitioners prior to their termination from service as apprehended in this case. 2 extra copies of the writ petition be furnished to Ms. Bhattacharya. Office released the matter again on 29/10/2020.
Lordship.
24 as motion for motion as fixed.
Even my lord, we are not made party in that petition also. We are not made party in the petition also.
Correct.
That's
They
why
could be
this
pleaded,
interim order
Lordship.
was
This is
passed,
not,
my lord.
this cannot be the plea, Lordship.
This order was.
You are responsible for the misery of your client. I didn't want to say this.
Yes.
You people practically don't know how to handle legal matters.
Because my lord, I have to.
All right, next matter.
Item 13.
May I please announce? My lord, matter relates to promotion, my lord. Listeners are working in the forester grade 1 in the forest department, my lord. And as per
Present form, it was maintainable, my lord, because 26 petitioners from different divisions have come. It has to be individual applications, my lord. In case if
No,
there is a
madam,
case. my lord.
we are.
Heard Mr. K. Counsel for the petitioner peruse the amendments made in the writ petition. The petitioners are aggrieved due to non-consideration of their case for promotion. Mr. D. Gogoi, understanding counsel forest department, has questioned the maintainability of the writ petition by contending that this writ petition is hit by misjoinder of cause of action. Mr. Gogoi seeks leave of the court to file an affidavit questioning the maintainability of the writ petition. In view of the above, issue notice returnable in 6 weeks. If he files an affidavit, we'll dismiss it.
My lord.
Since Mr. D. Gogoi, learned SC Forest Department, Assam, has appeared and accepted notice for all the respondents, no formal notice is required to send in extra copies be filed. This is case for admission. After 6 weeks, the question of maintainability of the writ petition is kept open and shall be considered at the stage of admission hearing.
Item 21.
Let's say petitioner is a diabetic patient, he's become poor. He filed an application for transferring him to his native place, and according transfer order has been issued at page 19. But till date, he has not been released for joining in his new place of posting by the circle officer.
Yeah, you obtain instruction, Mr. We'll have it on when? 29th? Yeah. 29th for motion, heard Mr. S. P. Goswami, and counsel for the petitioner. Peruse the statements made in the writ petition. It appears that the grievance of the petitioner lies in a limited sphere. That is, he has not been released by the concerned circle officer for joining in the new place of posting. Mr. C.K.S. Borua, learned G.A. Assam, prays for posting this matter again on 29/10/2024, so as to enable him to obtain instruction and appraise this court. 2 extra copies of the writ petition be furnished to Mr. Borua. List this case again on 29/10/2024 for motion as a fifth.
And pending issuance shall not be
Pendency of the writ petition shall not be a ground,
for release
shall not be a bar for the authorities to release the petitioner,
to enable him joining in the
so as to enable him to join in his new place of posting.
public.
Item 32.
Here the petitioner are working as nurses, my lord. And my lord, they were appointed in the year on 13/10/2015. At the time of appointment, my lord, their pay was fixed, if lordship would find, at page 49. The pay was fixed at rupees 5,600 and gate pay of 2,400, my lord. That was in 2015. In the year 2022, they made a refixation saying that there was some anomaly and they started recovery from us, my lord. As of today, what should be the correct pay or what is the scale, my lord, that we can argue later on. As of today, my lord, this recovery from our pay in view of frequency, which says that 5 years you pay, you don't recover as such. Grade 3, you don't recover as such. And without notice, you don't recover as such, my lord. Today, if lordship issues a notice, what should be the correct pay, we'll argue later. Today, my lord, I am praying for a stay on the recovery part. Since it is an admitted position, my service book, their appointment letter says I was entitled to 5,600. 2022, 7 years down the line, they say no, it should have been so and so, we are recovering. And that recovery notice is not given to me. How much is being recovered is not told to me. I just know a sum of rupees 3,000 is being deducted.
This recovery is happening since when?
2022, my lord, we came to know about this manner of recovery in 2023 December, my lord. We made an application, they have not stopped the recovery.
Who is appealing?
Recovery in law would not perhaps be permissible, madam.
Yes, who is appealing? What is your submission? Then we'll mention that you don't have any, you are not opposing the prayer for interim relief. Who is making the recovery?
It has come from, my lord, the Finance Pay and Research Department, my lord.
Finance?
Finance Pay and Research Department said, my lord, it has to be revised and recovered. I'm sorry, my lord, it is the Additional Chief Medical and Health Officer, Gwalpara, who's making the recovery. Health and Family Welfare Department.
All right, I heard Mr. R. Majumdar, learned counsel appearing for the lead petitioners. The petitioners herein are all working as auxiliary nurses, midwife, bracket A&M. And full stop. Their appointment was made on the basis of fixed pay scale of rupees 5,200 dash 20,000, fixed pay scale of 5,200 dash 20,200, along with grade pay of rupees 2,400 plus other admissible allowances by order dated 13/10/2015, issued by the Director of Health Services, Assam. Full stop. Notwithstanding the same, after 7 years of rendering service by the petitioners, the authorities have started deducting an amount of rupees 3,000 unilaterally on the ground of excess payment of salary. Mr. Majumdar has relied upon and referred to the decision of the Supreme Court in the case of State of Punjab versus Rafiq Masih. Give him the citation.
2014, 15, 4 SCC 334.
State of Punjab versus Rafiq Masih.
State of Punjab versus Rafiq Masih.
To submit that the petitioners, being employees of the grade 3
Madam.
category, recovery of excess drawal, even if any, would not have been made by the authorities, that too without serving prior notice upon them. As such, a prayer has been made for issuance of an interim order of protection. The learned Standing Counsel for Health and Family Welfare Department, Ms. D. Bora, has prayed for some time to obtain instruction.
Yes, Lordship.
In view of the above, issue notice returnable in 6 weeks. Since Ms. Bora has accepted notice on behalf of respondent number 1,
1, 3, and 5. Lordship.
1, 4 and 5.
Yes, 1, 4, and 5.
4 and 5, Mr. R. Borpuderi, learned HC Finance for respondent numbers
2 and 6.
2 and 6, and Mr. S.K. Mehdi, learned counsel for respondent number 3. Service of notice deemed to be complete in this case. Extra copy of the rate petition be furnished to the learned departmental counsel within 3 days from today, so as to enable them to obtain instruction. Hard on the prayer of interim relief, the said prayer will be considered on the returnable date. However, having regard to the overall facts and circumstances of the case, as well as the law laid down in the case of Rafiq Masih Supra, it is hereby provided as an ad interim measure that no further recovery shall be made from the salary of the petitioners in the returnable date. The above order shall be subject to review based on the stand of the departmental authorities brought on record by filing affidavit on or before the returnable date.
Obliged, Lordship.
Supplementary list from motion item 62.
Need to be Lordship was pleased to grant timely respondents to obtain.
Lordship, I have taken up with the authorities, Lordship, but they have prayed for at least some accommodation, Lordship, to give us the proper instructions.
No, the hearing is fixed on 28, Monday, my lord. This is the order.
All right, heard Mr. This is what
I'm praying
criminal
for
and
the-
departmental proceedings.
Lordship.
Yes, simultaneous
Mr.
procedure.
H.K. Das, counsel for the petitioner. This matter was fixed today by order dated 23/10/2024, requiring the learned government advocate Assam to obtain instruction. So today when the matter is called up, Ms. Bhattacharjee, learned additional senior government advocate Assam prays for 2 weeks further time to obtain instruction in the matter. In view of the above, this writ petition is directed to be listed again after 2 weeks. However, considering the facts that the departmental proceeding is fixed on 28/10/2024, for ends of justice, it is provided that no effective order will be passed in the departmental proceeding against the writ petitioner on until further orders.
Lordship.
No adverse order will be passed against
The
the,
DP may be stayed, my lord, because they will proceed with the DP, my lord.
no adverse order,
Departmental proceeding may be stayed.
no adverse order will be paid. What is the problem with that?
Probably they may understand that they will continue
But
with
you
the DP.
understand what is the meaning of it? The judges understand.
No. To stay that further proceed, no further proceedings in
No
that.
adverse order will cover everything.
Pleasure.
The notice has to be issued perhaps.
No, we're fixing it for,
Fine, fine.
this for motion. No adverse order will pass against the petitioner in the department proceeding.
My appraisal option. The petitioner, my lord, belongs to my lord, Kachari tribe, and which is recognized in my lord Karbiang. Then my lord, an advertisement was issued by Ames authority, my lord, intending to, my lord, give appointment number of posts, my lord. And Guwahati, initially Guwahati was not included, subsequently there was an addendum, and by virtue of that notification, Guwahati was included, notifying number of posts for appointment. Then my lord, she applied, and ultimately my lord, she got selection. That one, my lord, she was asked to appear before the scrutiny committee to produce the original testimonial she had produced, and they sought for a report from Deputy Commissioner Karbianglo. What is the status of the petitioner? Then Deputy Commissioner says she belongs to Kachari community, therefore she is a scheduled tribe playing in under Karbianglo. Whereas this certificate which was issued by the Deputy Commissioner, making it applicable to all other, my lord, all other districts except Karbianglo and Dima Hasao. Because in Karbianglo and Dima Hasao, my lord, ST playing are not allowed to project themselves as ST. Then, my lord, they sought for another report from Home Affairs. Same status report, my lord. All of a sudden, my lord, when I was expecting to get an appointment, because my name appeared in the select list, my lord. Provisional select list, subject to condition that they are supposed to allocate these seats. And later on, they allocate this seat in favor of, my lord, me in, my lord, Delhi. In the meantime, my lord, there was a clause in the advertisement that we have to exercise our choice by giving preference. Then I, my lord, exercise my choice, my lord, preferring Guwahati, and AI, my lord, Guwahati Medical Institute, All India Medical Science Institute as a first preference. They did not bother, my lord. Whatever choice I have exercised, they intended to give me appointment in Delhi. Then I was asked to appear. I appeared, produced all documents. All of a sudden, they issued this, my lord, impugn order. There is the last order.
What is the impugn order date?
Impugn order is 19/9/2024.
You have written 2023 in your annex synopsis.
253 at page 253 impugn order, annex 16, dated 19/9/2024. Saying that, madam, my certificate is not valid. Therefore, Lordship will examine this question. Of course, my lord, number of questions arise whether petition is maintainable, because, my lord, I sought for, my lord, certain protection by referring to clause, my lord, 2 and amended clause 1A.
Where is the impugn order page number?
253. 253. Yes. Para 2. However, as part the central list scheduled tribe in Assam, the borough is not recognized as scheduled tribe in my autonomous district. And I am not, my lord, I did not make any application for appointment under, my lord, Karbi Anglong. Therefore, my lord, what is the question to say or to hold me not eligible? And there is a decision of my lord on this point. A certificate issued by any state government shall have the application in, my lord, Union Territories. Or any other.
So what has happened now? You are out.
I'm out. And my position is, my lord, better position than any other country. My position is 278.
What order are you seeking now?
My lord, at the moment, this order may be suspended or Lordship will examine this matter, whether I am otherwise entitled to get the appointment. Yes.
Yes.
Impugn order is of Ames, New Delhi, my lord. I am appearing only for Karbi Anglong Autonomous Council. Only point out that the Boru community is not the recognized scheduled tribes in the hill district. Page 133, my lord. Constitutional order is there.
No, but it's the state of Assam.
My lord, no, my lord, if your lordship look into 130, Constitutional Order of 1950, that in the autonomous district, my lord, who are the scheduled tribes for the autonomous districts, they are enlisted.
No, that is which communities of which district comes under the scheduled tribe category.
My lord.
But once in the
No, my lord, there are two orders, my lord. For the state of Assam, rest of Assam, my lord, there is another list, and for the autonomous district, another list. There are two
But
lists.
she never applied for Karbi Anglong.
It is not, my lord. If he is a resident of Karbi Anglong, my lord, whether she can be recognized as a scheduled tribe, my lord, that is the point, my lord. Lordship will look into page 130, my lord. Constitutional order is there. He annexed it.
It will never be classified in there.
But regarding selection and all these things, I am not there, my lord. Only point out, my lord, that position, page 133.
Yes.
Part 2, Assam, in the autonomous district of Karbi Anglong and North Kasar Hills. These are the communities, my lord. These are the recognized scheduled tribes, my lord. Next page is page 131. That is for the, in the state of Assam, including BTC, my lord. That is a part 2, my lord. Then the Boru and Boru Kasar is the, for the state of Assam, not for the autonomous district, my lord.
No, but she did not apply for Karbi Anglong.
No, my lord, as the petitioner applied on a certain category as per the constitutional order, scheduled tribes, and she's a resident of Karbi Anglong, and she is not recognized as scheduled tribes in the Karbi Anglong Autonomous District, my lord. That is only the point.
And she is a Boro.
She is Boru community, and she is not a Karbis. So there is a point is there, my lord, that I have the information that Ministry of that Boru communities, my lord, all Boru, they have submitted memorandum to the ministry. Ministry sought to include them in the that in the particular autonomous district, and we have sought the opinion. We objected to that. All these things are there, my lord. So they are the whether they are recognized as scheduled tribes point or not, my lord. That is, if that point is required to be decided, my lord, and I can only submit on that point, my lord. Regarding the other matters, selection and other things, I have nothing to say, my lord.
May I just point out one thing? In the advertisement, there is nothing at all, nothing is notified in the advertisement. The candidates who are residing in a particular area and which is not
Right.
recognized.
Who is appearing for the union, for the Ames?
They don't have any standing of like.
Response number?
Number 1. 1 and 2.
All right, we'll issue notice on the main as well as the interim prayer.
Yes.
When? Short date, 8th of November.
At least one portion is directed to be resolved. Because I was selected candidate on merit.
That post she was holding shall be.
At the moment, I am working in medical college, Defu Medical College, as a staff nurse. I am having all experience. I am having all, my lord, otherwise eligibility. They selected me, and the seat was allocated.
So you are working somewhere?
I am working in Defu Medical College.
Then what is the problem?
Otherwise, not supposed to be filled up. Only now there are 6 number of posts.
Right, I had Mr. Castle and counsel for the petitioner, peruse the amendments made in the writ petition. The order dated 19/9/2024. By means of which the candidature of the petitioner for the post of nursing officer at Ames, New Delhi in NORCET -4 (2023) was cancelled on the ground that the petitioner is not a petitioner does not belong to a recognized scheduled tribe from the district of Karbi Anglong. The instant writ petition has been filed, inter alia contending that the impugned order is illegal. Mr. Purkasto has also prayed for an interim order protecting the interest of his client, full stop. Mr. J. Chutial and SC Karbi Anglong Autonomous Council, KAC, on the other hand, submits that since Bodo is not a recognized scheduled tribe, since the Bodos within courts, Bodos living in Karbi Anglong are not included in the central government order of 1950 pertaining to the scheduled tribe communities in Assam, she cannot get the benefit of a reserve category candidate bracket ST, and therefore there is no illegality in the impugned order. The Learned Standing Council, however, submits that he would have no submissions to make as regards the validity of the selection of the petitioner. Full stop. Mr. S.P. Chaudhary, Learned CGC, appearing for the respondent number 1, 1 and 2, prays for some time to obtain instruction. Considering the nature of dispute involved in this proceeding and the urgency expressed in this matter, this court is of the opinion that the issue raised in the writ petition would call for expeditious consideration by this court. As such, issue notice returnable on 8/11/2024. Since Mr. S.P. Chaudhary has accepted notice for respondent numbers 1 and 2. Who is for 3?
He lost his national commission for. So if you lost for 3. 1, 2, and 3.
1, 2, and 3. What about 4?
4 is probably they are having their one set of council. It's a 8 loss. 4 to 8 loss. Notice me.
Mr. C.K.S. Borua, Learned CGC, Learned G. Assam for respondent number 9, and Mr. J. Chutia for respondent number 10 and 11. Mr. J. Chutia for
Respondent number 10.
11. 11 also.
Deputy Commissioner.
C.K.S. Borua, 9 and 11. Service of notice upon respondent numbers 1 to 3 and 9 to 11 is deemed to be complete. Extra copies of the writ petition be furnished to the Learned Departmental Council so as to enable them to obtain instruction. Petitioner to take steps for service of notice upon respondent number 4 to 8 by registered ready within 2 days from today. This case again on 8/11/2024 as a fixed item. The prayer for interim relief will be considered on the returnable date. But you can't serve notice so early.
Yes, madam. That is a problem.
28 will not be possible. You make it 22 November. 22 November. Yeah. The said prayer will be considered on the returnable date. However, as an ad interim measure, it is hereby provided that the post offered to the petitioner shall not be filled up by any other candidate till the returnable date.
May I be before receipt? My lord, is regarding my lord pension matter, my lord. I have retired, my lord, almost 2 years back, my lord. All pension papers were prepared, my lord. PBO is here, my lord, annexed 2. Only thing, my lord, grievance is, my lord, kindly come to page, my lord. Page, my lord, page 49. My lord. Page 49. Page 50, my lord. Date of retirement, lordship. Page 50, my lord, lordship what?
Oh, we'll issue notice at this stage.
Yes, my lord. But Lord, there is small prayer, my lord, entering, my lord, because error pension is already accumulated.
But Mr. N. Morel and a counsel appearing for the petitioner, there was the statement made in the petition. The petitioner herein, who was serving as a grade 4 employee in the office of Assistant Executive Engineer, Public Health Engineering Department, Chowki Khola Subdivision at Sarihajan in the Karbi Anglong district of Assam, had retired from service upon attaining the age of superannuation with effect from 30/11/2023. The grievance of the petitioner is that although she is entitled to receive pension, the pension of the petitioner has neither been settled nor any retirement dues been paid to her till today. For now.
Has been paid, my lord. It's 13, my lord.
Other benefits given and TCRG only provisional given. And
The pension of the petitioner has not been settled. Pension has not been.
no, my lord.
Yes,
Yes,
correct.
correct.
So been sanctioned, my lord. TP order was also issued, my lord. He has annexed the document, my lord. That is, my lord, para 11, page 12. What is the amount he has received, my lord? The pension payment order has also been annexed by the.
So what is the grievance here?
My lord, they are withholding, my lord, not releasing.
SBI, not us.
And
Who is withholding?
my lord, nothing has been released, dispersed.
The
Continuous
the
persuasion, my
grievance
lord.
of the petitioner is that although the authorities have sanctioned her pension by issuing PPO,
Yes,
the
my lord.
bank authorities.
Second, my lord.
Huh?
Second grievance is, my lord, that
Let's
pension-
finish one first, then we'll go to second.
yes, lordship.
Who has withheld your pension?
Possibly, my lord, State Bank, my lord.
The
Respondent number 10 and
11,
11.
That is the branch manager SBI Bokajan has unauthorizedly withheld the pension of the petitioner, thus causing serious prejudice to her interest. Full stop. It is also the grievance of the petitioner. Yes, what is
My lord,
second?
secondly, my lord, the calculation part, as I indicated, page 50, my lord. Last, it was supposed to be taken care of last basic salary, my lord. But they have taken the last basic salary, my lord, rupees, my lord.
The second grievance of the petitioner is that her pension has also not been properly fixed
Yes.
by taking note of the last applicable pay scale. Hence this writ petition.
And thirdly, my lord.
Oh, you have a three
Only,
also. How
my lord,
many?
only.
Total how many?
They want
3,
recovery,
4,
my lord.
5, how many?
Recovery, my lord.
Recovery.
Yes.
What recovery?
Excess payment. That is what they said. My lord, kindly
It
come
appears
to
that the
page
petitioner is
50.
also assailing the
52.
decision of the authorities to make recovery of excess payment.
They do here.
Page 52.
Excess drawal. Full stop. I have perused the amendments made in the writ petition, issue notice returnable in 4 weeks. Since who is appearing for whom?
I'm for the state, madam. Sabi Anglong is there.
Since Mr. D. Gogoi Leonard's SCPHE is appearing,
For one.
has
1 and 5.
accepted notice for respondent numbers 1 and 5. Mr. C.S. Hazarika, Leonard G. Assam for respondent number 2. Mr. R. Borpujari, Leonard SC Finance for respondent number 3 and 9.
I'm for 4, my lord.
Mr. B. Sharma, Leonard SC AG ANE, Packet Lower Assam for respondent number 4. So Mr. D. Gogoi for 1, 5, 7, 8 also.
And 6, 7, and 8.
Achha. 1 and 5 D Gogoi, no? Mr. J. Chutia for respondent number 6, 7, and 8. Service of notice upon respondent number 1 to 9 is deemed to be complete in this case. Extra copy of the writ petition will be furnished to the Learned Departmental Council, requisite in numbers within a week from today. Petitioner to take steps for service of notice upon respondent numbers 10 and 11 by registered post with AD within 3 days from today. Or on the prayer of interim value, the said prayer will be considered on the returnable date. However, as an ad interim measure and taking note of the law laid down by the Supreme Court in the case of State of Punjab versus
Traffic.
Rafiq Masih, reported in so and so, you will get it from it is hereby provided that till the returnable date, no recovery of any excess dwell shall be made from the petitioner.
Applies, my lord.
Only 3 or 4, you have, how many grievance?
Only
Ah,
that
you
much,
must
my lord.
mention, no, 1, 2, 3.
Only that much, my
Only
lord.
3.
I'm expecting for early recovery otherwise, my lord. Early dispersal.
Early disbursal.
Lordship. Applies, my lord.
For admission, item 33.
May I please, your lordship. Also, in this case, we have challenged the dismissal order, lordship, for unauthorized absence, lordship, whereas the petitioner services was utilized by the deputy commissioner office. Lordship, this matter was heard on 23 lordship 7 2024, and during the hearing, we have projected that there is two contradictory stand of the department as well as the deputy commissioner office. That's
So
why.
heard by which bench?
Lordship, this is not part of lordship. Therefore, the detailed order was passed on 23 7 2024, directing the deputy commissioner office to file a affidavit, lordship. Because fishery department has stated that the circle officer has no authority to issue the appointment of engagement order, lordship.
Think there was a question that lordship that he has not done his part, lordship. He has not.
So is it ready for disposal?
No, we have not filed our affidavit, lordship. Let us file the affidavit, lordship, because the instructions is available. The instruction of deputy commissioner
Then when will you file it?
at the earliest, lordship, because I'm appearing for the in the matter for the first time, so I will file in the with the.
Alright, so agree to a schedule. When can we fix this matter?
Let me fix a date.
At least 1 week time may be given to me.
Heard Mr. K. Kalidar, any counsel for the petitioner? Also heard Mr. CKS Burul and G. Assam appearing for the respondents who submits that instructions have been received and therefore a week's time be granted for filing affidavit. Prayer allowed on the request of Mr. CKS Burul. This matter is directed to be posted again on 6/11/2024 so as to enable the learned G. Assam to file affidavit.
I get it.
List accordingly.
No, sir.
Item 34.
Time to file rejoinder affidavit.
Mr. Nath, learned counsel for the petitioner, praise for and is granted 4 weeks time to file rejoinder affidavit.
Published.
Accordingly.
35.
Yeah, my lord, we need 2 weeks time to file our affidavit in opposition.
You are for whom?
I'm for petition, my lord.
Mr. J. Sharma, learned counsel is present for the petitioner on the request of Mr.
W. Hamid.
W. Amen, learned counsel appearing for the APDCL authorities. 2 weeks further time is granted for filing counter affidavit. List this matter again after 3 weeks.
Item 36 to 44.
In this matter, my lord, the respondent has not filed the affidavit, my lord. But there is a series of matter, my lord. In grade 3 matter, my lord, personal department has filed affidavit in opposition, my lord. The issue, my lord, the broader issue, my lord, in this matter, the reservation system, my lord. It seems from the affidavit that they treated it as the vertical reservation. Although, my lord, under the scheme of the statute, my lord, it's a reservation or my lord, benchmark reservation is a horizontal reservation within the reservation of PWT as a horizontal.
What is to be done? Final disposal now?
No, my lord.
Then why are you arguing on merit? Reservation, no reservation, that will argue if the matter. So is it to be taken up for disposal today? Huh? Then why? Why is he arguing on merit then?
Well, in some cases, there.
Yeah, there are almost 50 numbers of cases. In 8 numbers of cases, I personally has filed the affidavit on behalf of the.
No,
person.
what is to be done in these
Yeah, at least
cases?
the matter will be adjourned today and in the department to file the if concerned.
Which department?
Personnel department.
Who is appearing for personal
I'm
department?
paying yourself. So, let's say in 37, 39, 40, 41, we have filed our affidavit. And no, we have received the instructions and rest of the matter, we have not received the instructions. So, let's say as a whole, in all the matters, we will file the affidavit also. If it.
How much time you want?
Some time may be required in this case, also.
There is some interim order.
My lord.
Operating.
Yes, sir.
But Mr. S. K. Roy, learned counsel appearing for the writ petitioner in all these cases. Mr. C.K.S. Burul, learned government advocate Assam submits that instructions have been received for filing affidavit in some of the cases, whereas other instructions are still awaited. The learned government advocate Assam therefore prays for 4 weeks further time to obtain instruction and file affidavit. Who else is appearing for whom?
Lordship, I am appearing D for respondent number 2. Social Justice and Empowerment
Ms.
Department.
D. Jain, Learned Standing Council, Social Justice and Empowerment Department. Ms. M. Kotoki, Learned Standing Council. Animal,
I think number 38, 40 and 40.
Animal Husbandry and Veterinary and Animal Husbandry Department. And no, which department?
I did.
IWD.
And
Water
Miss-
transport.
Your name, please?
Next for us.
Ms. S. Bora. On behalf of? And Ms. M. D. Bora, Learned Standing Council, IWD Department are also present and have
Lordship, I am
sought for
appearing for
Transport Department. Yes,
IDAS on behalf of the Permanent Health Department.
Mr. D. Upamanu, Health Department are also present and have made a similar prayer to complete pleadings on behalf of their respective clients in this batch of writ petition. On the request made by Learned Council for the respondent, these matters are directed to be listed again after 4 weeks. In the meantime, parties to exchange pleadings. Yes,
Well, a date may be.
I got 45.
A date may
you
be-
count the date after 4 weeks.
Lordship, the matter may kindly be passable for the time being, Lordship. The dealing
Pass
council.
over the day on the prayer of petition.
Lordship. Lordship, there is an interim order.
Interim order passed earlier tonight.
No, Lordship, there is an interim order and the cause of action never arises here, Lordship. All the respondents are from Bangalore, Lordship. No territorial jurisdiction lies, Lordship.
What is this matter? about?
There is a stay order, Lordship. Matter relates to the appointment of airman, Lordship. Musician in the Agnibir, Lordship. And there is, your Lordship.
Pass over for the timing, yes.
I
Call,
got
call.
46.
Timing.
Mr. Fukan was to appear on this matter.
None appears with the petitioner on call. Matter stands adjourned for 2 weeks.
Supplementary list for admission items.
Yes,
Mr. is coming, he's on road just for few moments. If never.
what do you want me to do?
Let's just pass off for the time being, Your Lordship. He's on the way, Your Lordship. That's right. Oh, he's come, Lordship. He's arrived.
We have received instruction to file affidavit. Yesterday I have got it.
All right, your name, please?
Kalyani De Lordship on behalf of Mr. NNB Chaudhary.
Sorry, in
Ye De.
so for the petitioner also had Mr. T.C. Chutia, learned additional senior government advocate Assam, who submits that he has received instructions in the matter and therefore be granted 2 weeks time to file affidavit. Prayer allowed. Let the matter be listed again after the affidavit is filed on record by the respondents. Let the matter be listed again after 3 weeks. In the meantime, the respondents may file counter affidavit.
There is an interim order, Lordship.
No interim order.
Interim order, Lordship. Earlier passed.
That order is.
The prayer for interim order will be considered on the next day.
Deeply obliged.
Yes.
Item 45.
46. 44. 44 is over long back.
For order. Item 47.
May I please your Lordship? Lordship, the step has been already taken.
Step has been already taken. When?
Yesterday.
The Learned Council for the petitioner submitted the steps for service of notice upon the respondent number 5 has been taken yesterday. Office to verify and list the matter with appropriate office. Mr. N. Upadhyay, Learned Council is present for respondent numbers
1, 2, 3, 4.
1 to 4.
Obliged.
Item 48.
May I please, your lordship, lordship, the standing council for the soil conservation is unwell, your lordship. The matter may be adjourned for a day, your lordship.
Matter speaks for filing of affidavit by the respondent number
We'll have it on Tuesday. Ms. N.S. Thakur, you are available 29th
29
or 30th?
on 30th.
30th. So into the petition on the request made on behalf of the Land Standing Council Soil Conservation Department. This matter is directed to be listed again on 30/10.
Oblige, your
May I please, your lordship, apologies, your lordship, to interfere, my lord, in the matter. My lord, there's a matter, my lord, item 46. My lord, I was on legs on the other court, my lord. I could not come, my lord. My lord, can it be taken up after some time, my lord? Back maybe at 2, maybe. My lord, or maybe now also, if your lordship pleases, my lord. Apologies, my lord, for the, my lord, dullness, my lord. My lord, I was actually on legs, your lordship. I completely missed it, my lord.
So we'll have it next week.
My lord, certain urgencies there, my lord, in this matter regarding, my lord, the candidate, my lord, for the post of, my lord, Airport Authority of India, junior assistant, fire services, my lord. So on the last occasion, my lord, he was disqualified. So ultimately, the court had interfered. But your lordship, it takes up today, my lord, if
It
possible.
will not be possible. Choose any other date.
My lord, then Monday, my lord.
Monday.
Deeply appreciated.
List again on Monday.
My name may be recorded in that case, because I was there, lordship.
Mr. D.
D.
Decker,
Decker.
council appearing for the, is there already, your name is there.
Yes.
Then,
No, in the order, lordship.
so Mr. D. Decker, Learned Council is present for the respondent. Mr.
A.
A.
Fukan for petition.
Learned Council is prepared for the petition. List this case again on Monday as a fixed item. With the date.
Oblige, lordship.
Deeply appreciated.
Item 50.
Relating to my pension, whether no response has been received from the respondent. Lordship, they were supposed to file amended cost title, Lordship.
You have not filed amended cost title. Mr. Sharma, Learned Council for the petitioner prays for is granted 1 week further time to file amended cost title.
Fine, nice.
List accordingly. May please, your lordship, on the last date.
No. The same prayer, your lordship, and the standing council is unwell, your lordship. For the soil conservation department.
AB Dr. Worship. The petitioner's counsel is present on the request made on behalf of the respondent. This matter, respondents, this matter is directed to be listed again after a week.
Now, this was issued upon number 6 and 7. Accordingly, we have taken steps on the 6 and 7. There's nothing.
You have taken steps.
Yeah, my lord. I have taken step on 5-9.
Heard Miss, your name please?
Iwapangla.
T. Wapangla, counsel for the petition. Perused office note dated 22/10/2024. Await service report on respond number 6 and 7 for 3 more weeks. List accordingly.
Please. Item 49.
May pleasure, lordship. Lordship, in this matter, all services are completed, my lord.
My lord, I am for the respondent number 4, my lord. I press thumb tape to file objection, my lord. Opposite party number 4.
Learned counsel for the petitioner submits that service is complete in this case. Mr.
K.M. Hassan.
K.M. Hassan, learned counsel appearing for the respond number 4, prays for 2 weeks time to file affidavit in the matter. Since the respond numbers 1, 2, and 3 are represented by the state council, hence it is apparent that service of notice is complete in this case. Let this matter be listed again after 2 weeks. In the meantime, the respondent's counsel may file affidavit.
But 53, my lord, I'll see accommodation for today, my lord. There was a IA file, my lord, for modification of an order passed by this court, my lord. That's because if we go back on the original order, my lord, the operative part was also considered. But in the proceedings, my lord, some other orders were passed, directions were passed, my lord.
No loss.
No, that you want to file objection.
No, he has to file. I have filed IA, my lord. And IA has come.
You filed IA for what?
I for modification of order passed in this proceeding, my lord, of an order dated 26/7/23.
Do you have any objection?
Lordship,
Huh?
because Lordship, I what provision there?
Do you have any
Lordship,
objection?
I have no
Have you filed objection?
Lordship,
Then file it.
Lordship.
Mr. D. Gogoi, learned counsel for the applicant is present on the request of Mr. J. Kalita, learned counsel appearing for the. Who is the applicant's counsel here?
I am Lordship.
No, in contempt petition, he's the petitioner. I am the applicant in that IA, my lord. I have asked for a modification of an order, my lords. He's the opposite party there, my lords. They
D.
connected
Gogoi,
IA.
learned counsel for the applicant
My
in
lords.
this case. Also had Mr. J. Kalita, learned counsel for the OP stroke contempt petitioner who seeks 10 days further time to file objection opposing the prayer made in the IA.
Yes, Lordship, regarding maintainability of the IA also, Lordship. Once Lordship has already held that this petition
Yeah,
has been
allowed.
opened as valid.
This matter again after 10 days. In the meantime, objection is anyway not lodged.
May to the lordship. Lordship, this I is for amendment of the prayer, lordship, in the main petition.
Who is appearing for the respondents? Any objection?
No, Lordship.
Huh?
I am appearing for Pensionary. No,
No objection. Take down. Heard Mr. Sharma, learned counsel for the heard Mr. R. Sharma, learned counsel for the applicant. Also heard Ms.
and Bora.
M. Bora, learned standing counsel, PNRD Assam, appearing for the respondent numbers 1, 2, 3, and 6. Mr. C.S. Hazarika, learned G. Assam is present on behalf of respondent numbers 4 and 5. 4 and 9 is appeared for respondent number 7. His IA has been filed with a prayer to amend the prayer portion made in the writ petition, in the connected writ petition, on the grounds stated therein. First up, the learned counsel for the respondent submits that they would have no objection to the prayer for amendment of the writ petition in the manner indicated in the IA is granted by this court. Having regard to the stand of the respondents and considering the ground on which the prayer is made, same stands allowed. The writ petitioner stroke applicant is permitted to amend the writ petition in terms of the projection made in the IA. Amended writ petition be brought on record within 2 weeks from today. IA stands disposed of.
Item 65 to 58.
May it please your lordship. Lordship, here we have filed an IA for impleadment of respondent number 3 and 4, my lord. Respondent number 1 and 2 has been replaced, my lord. 2 has not. 3 and 4, lordship, 3 and 4.
How many IA?
Total 4 respondents, my lord.
How many IAs have you filed?
There are 4 IAs, my lord. Today, only 2 IAs has been listed, my lord. Item 50, 55 and 56.
I think 55, you write, heard Mr.
B. Hazarika.
B. Hazarika, and counsel for the applicant. Also heard Mr.
I'm in 55 for respondent number 2 only.
Mr. S.S. Roy, learned CGC appearing for respondent number 2.
For respondent number 2. in
Who else is there?
55.
In item 55 now, don't talk about any other item.
55.
Only 55, who else is appearing? Who else is appearing in 55?
I'm on.
You are the only one.
Yes.
None has appeared for the remaining respondents. Stop. This IA has been filed with a prayer to implead the officials, the department, the secretary to the government of India is being impleaded, and I'm recording that you don't have any objection. You will have to bear the consequences of that.
Lordship, today notice will be issued on.
Huh?
Today is the first time notice will be issued. Notice has to be issued.
You are there already.
I am for only for respondent number 2.
Okay, this IA has been filed with a prayer to implead the opposite parties, the respondents in the connected contempt case. First up, I peruse the grounds on which the prayer has been made. Prayer has been made. If you notice, returnable in 3 weeks. Mr. S.S. Roy, and CGC has appeared and accepted notice for opposite party number.
It will be in the main contempt case respondent number 2. Here they have not.
IA.
IA has not made him a popular. IA.
Respondent 3 and 4.
Two.
So issue notice returnable in 4 weeks, applicant to take steps for service of notice upon the opposite party. Chalo. And same prayer,
Lordship.
in item 56.
56, 57, and 58. But my lord, in the item 57 and 58, I has not been listed, my lord, today.
56 also same thing.
But I have the filing number, lordship.
Huh?
Can it be called for?
No. It has to be listed.
In 56, my friend has appearing in 56. 56, I mean.
No, but in the IA, he has not impleaded you. You are
No.
appearing for the opposite party,
No.
respondent number 2 in the contempt petition. Then you write SS Roy, CGC has appeared for the respondent number 2 in the contempt petition. The same thing is R Devi for respondent number 2 in the contempt petition. Yes.
Item 59.
And 57 and 58 list along with the IA.
May I please your lordship? The I is for production of the copy of the order in judgment dated 7.
Taken note of it. Yes. Ms. So-and-so has appeared for the applicant. This IA has been filed for the purpose of placing on record the copy of the judgment passed by the division bench, passed by the
Single
single judge in WPC number 4401 public 2009. Ms. Boral and a counsel is present for the
NHM.
NHM and does not have any objection if the judgment is taken on record. In view of the above, since IA is hereby admitted, and shall be tagged with the writ petition, which will be considered at this stage of final hearing.
Oblige.
Item 60.
May I please? So the facts of the case is that, my lord, on 9/2/2023, the petitioner was in connection with the departmental proceeding was suspended. Afterward, my lord, we approached for the honorable court seeking relief of reinstatement, etc. Now, finally, my lord, this honorable court passed an order on 24/7/2024. Lordship, kindly have a look to I page 14.
What is this IA for? What is the?
My lord, I we have filed basically, my lord, there is a direction from this honorable court to reinstate us. Now, instead of reinstating us, my lord, earlier they have made a submission, the inquiry was completed. Now they have issued us notice for cross-examination. A wrong submission was made on last occasion only to resist our reinstatement, my lord. Despite of direction given by this honorable court reinstate, my lord.
Mr. S. Samuel and a counsel for the applicant submit that notwithstanding a categorical order passed by this court for reinstatement of the petitioners back in service, the authorities are trying to overreach the order of this court and are denying reinstatement by taking a dubious stand. Mr. C.S. Hazarika, learned government advocate Assam, prays for 2 weeks time to obtain instruction in the matter. In view of the above, list this IA after 2 weeks as a fixed item. In the meantime, the learned government advocate Assam may obtain instruction and file objection if any. It is made clear that the IA will be taken up for disposal on the next date fixed.
My lord, deeply.
Lordship, this matter notice has been sent on 14/10/24, lordship. Service report
Not
is
14, 410.
notice has been sent, lordship, as per office note, lordship.
Okay. Notice sent on 4/7. 4/7.
Notice, yes, lordship.
Your name, please?
M. Nirola, lordship.
This M. Nola and counsel is present for the petitioner. Peruse the office note dated 14/10/2024. Await service report on respond numbers 4/7 for another 3 weeks. Step on.
Lordship, the matter is urgent, lordship, can be fixed on next week, lordship, because the
Good.
of my account has been freeze.
2 weeks.
Timing matter, admission matter, item 45.
Last item.
I'm sorry, lordship, I was not present.
So this is, what has this got to do with Assam? Why you are filing it in Guwahati High Court?
All the respondents are from Bangalore. Every test has been done at Bangalore.
They are from this place, lordship, that is the reason.
But you have to move they are from Allahabad.
Bangalore, every test, medical test, the review medical test, own statement at paragraph 6, 7 and 8.
That we understand, lordship, at the interview, everything was done in Bangalore. But the thing is, since the petitioners are from Assam, lordship.
No, but it is the respondents which will decide the jurisdiction, not the petitioner.
I'll be relying on ONGC case, lordship.
You withdraw liberty to move the,
Lordship, let me take instruction, let it come.
oh, we cannot entertain this petition.
I understand, Lordship, but still, Lordship, maybe Monday, Lordship, today is
No,
Friday.
what, supposing your clients refuse,
Ah.
then also we'll dismiss it.
But still, that is
What,
true,
what
Lordship.
instruction you want to take?
No, Lordship, on my own, I do not want to do that, Lordship. Withdrawal, I'll
No,
do
you,
it. I'll
we'll
convince.
record that you have opposed it. His submission you have opposed, we'll record.
But then, Lordship,
Yeah, only we are saying is you can't compel the High Court to entertain a petition
I
unless
understand.
you can't, that doesn't depend on your client's opinion.
Correct, Lordship. But still, Lordship, do I get even a phone call to make and submit that? Because
On the prayer.
I understand, Lordship, I have to withdraw.
Each Chakravarti and other CGC appearing for the respondents have raised question, has questioned the maintainability of this writ petition on the ground of want of territorial jurisdiction by contending that all the respondents are from Bangalore. Therefore, it is the High Court of Judicature at Karnataka, which will alone have the jurisdiction to entertain this petition. Responding to the above, Ms. Majumdar, learned counsel for the writ petitioner, has paid for posting this case again on 29/10/2024, so as to enable her to obtain instruction. Prayer allowed, this matter again on 29/10/2024 as a fixed item.
Monday is
First-
28th, Lordship.
Huh?
Monday is 28th.
We are putting it on 29.
Fine.
Interim order passed earlier to continue till the next date.
Highly
But
obliged.
we'll close it in any case.
Yes, I understand, Lordship. I just want that they should know before I make a submission.